that's on.
The green light's still on.
I don't think that's anything to do with it. I think it's...
Oh yeah, mine. That sounds like it's on, doesn't it?
Shall I just say something and see if it works?
Testing.
Testing. Does that work?
Okay. reckon that's it.
I think so.
Rotates fairly easily, doesn't it?
Throw the water jet.
Yes.
Good morning, everybody. It is now 10 o'clock, which means it's time for this pre-inquiry meeting to open. Can I just check whether everybody in the room can hear me through this microphone? Yeah, good. Right, okay, I'll do my best. We have had some uncertainties about the AV, but if you can't hear, just let us know and we'll do our best to be as audible as possible.
Would it help to move forward?
It won't come any nearer to where we're sitting. Is that better at that position? Good. Thank you very much. A related point on audibility is that the meeting is being live streamed so that people can follow things outside this room. That means if anybody who isn't at one of the tables does wish to participate and say something, you'll need a roving mic, and I think we have that's a facility available, so you'll just need to wait till that gets to you. Right, this is a pre-inquiry meeting concerning applications which have been made by Cambridgeshire County Council for the Cambourne to Cambridge order, an associated request for a direction that planning permission be deemed to be granted for the works involved, and an application for a certificate in relation to the exchange of open space land. A panel of 2 inspectors has been appointed to hold the inquiry and to report to the Secretary of State for Transport on the application for the order and the applications concerning deemed planning permission, and to the Secretary of State for Housing, Communities and Local Government on the application concerning the open space land. My name is Richard Clegg and I am the lead inspector in this case.
Good morning, my name is Jeff Underwood and I'm a planning inspector who's the other member of the panel on the case.
I'd also like to introduce at this point the 2 programme officers who you may have had contact with already, who are working directly to us. On my immediate left is Brenda Taplin, and next to her is Joanna Vincent. They're dealing solely with the administrative arrangements for the inquiry. And just a few housekeeping points that I need to deal with next. Firstly, if anybody has got a mobile phone with them, will you please make sure that it is switched to silent so that we're not interrupted by those going off in the room? I have to give the standard notice about emergency evacuation. There's no practice of the fire alarm today, I'm told, so if an alarm does go off, you do need to leave the building. There are doors close to the stage on either side which lead outside, and you can also exit through the main entrance. And I'm told that the assembly point is by the bike racks opposite the main entrance to the building. Toilet facilities are out through the double doors at the end of the hall and on the left. Can I just check whether people who are present have seen the agenda and our advance note for this meeting? I'm getting nods, that's good. And just a reminder that the pre-inquiry meeting this morning is concerned solely with the management of the case, so the inquiry hopefully will proceed efficiently. It's not to do with the merits and arguments in support of your respective cases. What I'd like to do next, now we've got the housekeeping points dealt with and introduced ourselves, is for the parties present to do likewise so that we know who's here today. Can I start with the applicant, please?
Or perhaps turn it on. Thank you very much for the warning. Good. I thought I had it turned on. I'll start again. My name is Neil Cameron. I'm King's Counsel. I appear together with Mr. Matthew Henderson, who sits to my left, who's also a barrister. And we are instructed by Womble Bond Dickinson on behalf of Cambridgeshire County Council, the applicant. So you have a list of appearances from us where we set out the witnesses we intend to call. Would you like me to run through it?
At the moment, we're mainly interested in who's participating at the pre-inquiry meeting, Mr. Cameron. Yes, we've got the advantage of a long list of witnesses, which I take it is for the inquiry itself.
Certainly, sir.
First of all, before we get to that, is anybody else from your team intending to participate at the meeting today?
There are other members of the team here. They're not intending to participate. I can tell you who they are, but it may be better just to tell you who they are if we need to call on them.
By all means. Do you want to do that, Mr. Cameron, then just...
Certainly, sir. I've got here Mr. Joe Baker, who's the project manager at the Greater Cambridge Partnership. We also have Mr. Andy Saunders, technical director at WSP.
Yes.
And we have Mr. Ralph Lewis, who's an associate director at WSP on planning. And we've got Mr. James Franklin, who's from CBRE on land acquisition matters.
Right, and I think that all of the names you mentioned, oh yeah, yes, we have got Mr. Lewis. They're all down as witnesses as well, aren't they, for the inquiry?
They are, sir.
Do you quickly want to mention who the other members of your team are for the inquiry, as you drew our attention to that, Mr. Cameron?
The other witnesses, sir,
yes.
Or certainly. We intend to call Mr. Baker,
Yeah.
Peter Freeman, who's the chair of the Cambridge Growth Company, John Lonergan, who's a technical director at WSP, who's going to give engineering evidence, Chris Whitehouse, who's also a technical director at WSP, who gives evidence on the business case, Mr. Saunders, who I've already referred to, Chris Carolan, who gives landscape evidence, Ian Ellis, who gives evidence on ecology, Chris Alder, who gives evidence on arboriculture, Toby Lewis on noise, Tom Wilson on heritage, Jack Southern on flood risk, and Paula Reason specifically on bats. And I didn't reread the names of the people I've just given you.
No, that's fine. Thank you very much. And can I just check? You said you were instructed on behalf of Cambridgeshire County Council. And I just wanted to be clear about the relationship with the Greater Cambridge Partnership.
So I said instructed on behalf of Cambridgeshire County Council because they are the applicant for the Transport and Works Act order. And so they are the applicant and we appear on behalf of the applicant. But Cambridge County Council are part of the Greater Cambridge Partnership. But the formal legal body making the application is the County Council.
Yes, but no separate representation from the GCP?
Not from the GCP, but other of the local authorities who form part of the GCP, as I understand it, are separately represented, and Ms. Nevin is here today on their behalf, so I'll let her speak in a moment.
We'll come to the other local authorities in a minute, but in terms of the GCP itself, their interests are dealt with through the County Council, is that right?
Correct, sir.
Yeah, with the County Council being the applicant because GCP are not in a position to be the applicant.
Correct, sir.
Thank you, Mr. Cameron. Right, next on my list was any other local authorities who may be present.
Good morning, sir.
Good morning.
I'm Claire Nevin of Council, and I'm here representing Cambridge City Council and South Cambridgeshire District Council, which are part of the GCP, as you've just heard. I'm just stepping in today.
Can I
sir.
sorry,
Yes.
can I just check I've got the details of your name down?
Claire Nevin.
Claire Nevin.
Yes, Nevin.
Right.
And it will be Esther Drabkin-Reiter representing at the authority. I'm stepping in for her today.
All right, you're here at the... Right, and sorry, and can you repeat her name?
Esther
Esther, yes.
Drabkin.
Sorry?
Drabkin, D-R-A-B-K-I-N.
Esther Drabkin, right.
Reiter, R-E-I-T-E-R.
Right. Also of council?
Also of council.
Right, and I think you said she would be representing both of the other local authorities.
Yes, sir. To my left, I have Chenge Taravinga, who is the team leader for NSIPs and major infrastructure for Greater Cambridgeshire. Would be helpful, sir, to go through who will be participating at the inquiry.
It would probably help our pen if a list could be provided in due course to the programme officers of witnesses. But yes,
Yes, sir.
Please give me the names. Could you start again with your colleague who's with you and just give me, could you just spell the name out for me, please?
Chenge, C-H-E-N-G-E. Taravinga, T-A-R-U-V-I-N-G-A.
Right. Yeah.
And then in terms of who will be participating, it's Stephen Kelly,
Right.
who's the director, and Mr. Kelly will be giving evidence on matter 1.
Right. So you're referring there to the statement of matters.
Yes, sir.
Yeah, just want to be clear so that people in the hall are aware of what you're referring to. And the statement of matters document was produced by the Secretaries of State and outlines the matters on which they want to be informed. When Ms Nevin refers to matter 1, she's talking about the aims and objectives and the need for the guided busway. Right, so that's
Mr. Kelly.
Mr Kelly.
Yes. At the moment, we're not anticipating any further witnesses because we are close to agreeing conditions with the applicant. But in the unlikely event that we can't agree certain matters, we would just reserve the position to call potential witnesses on matter 4, which is the effect of the implementation, operation and maintenance of the scheme on certain matters listed there. And if we do so, of course, we'll provide an update to the inquiry.
Yes. So are you envisaging just 2 witnesses at the moment?
Just 1 at the moment, sir. And because we're making good progress agreeing the conditions, we're not anticipating further witnesses at the moment.
Oh, I see. So just Mr Kelly?
Just Mr. Kelly, yes. And if further witnesses are required, which we think is unlikely, that would be on matter 4, and we will provide an update very quickly.
Thank you, Ms Nevin.
Thank you, sir.
I'd now like to come to other parties present and find out their interest, first in the pre-inquiry meeting and then the inquiry itself. Can I start? I'm going to go around the room in that direction, so they can start with the table down to my right, please, and find out who's there.
Good morning. My name is Stephanie Bruce Smith of Council. I'm instructed by Denton's UK and Middle East LLP on behalf of Clare Hall, Cambridge, or University of Cambridge.
Right, let me just get those details. Did you say Stephanie Bruce Smith?
Stephanie Bruce Smith of Council, yes.
And I think you said you were instructed by Denton's.
Denton's on behalf of Clare Hall, University of Cambridge.
Thank you.
I have a list of appearances.
That would be very helpful, yes.
I have paper copies, if that
Yes,
would be helpful, and
it
I
would.
can ensure that it is sent to the programme officer as well. Sorry, there's 2 copies.
Thanks, Jeff.
So as you'll see from the list, at the inquiry, Clare Hall will be represented by Harry Philpott, King's Counsel, as lead counsel. He is not here today at this inquiry meeting.
Yes.
And then you'll see that I will also be attending, so that my name's just under that as junior counsel for Clare Hall. You also have our instructing solicitors below that, and then the witnesses we plan to call. Would it help to identify who is here today? Or
Yes,
run
yes,
through-
please. If you could do as Mr. Cameron did,
Yes.
find out who's here today, and then just for completeness, go through the witnesses.
In terms of who's here today, in addition to myself, we have both Michelle Vass and Thomas Horner of Denton's in terms of instructing solicitor, and in terms of witnesses, we have Mr. Alan Short, President of Clare Hall University of Cambridge. So those are all the parties who are here today.
Yes.
And then at the inquiry, we also have Cameron Hyder of Pulsar Transport Limited giving evidence on transport and alternative routes. Graham Sinclair of Create Consulting Engineers Limited giving evidence on flooding. Jodie Blacklock of Create Consulting giving evidence on acoustics. Fiona Lamb of Avanti Architects giving evidence on heritage matters. David Conboy of Newsteer giving evidence in relation to compulsory acquisition and compensation. And finally, Jessica Wilson of Newsteer giving evidence in relation to planning matters.
Thank you very much. Yes, go ahead, please. Is it switched on? I think there's
Sure. Good morning, sir. My
morning.
name is Jack Parker of Council. I am here representing Cambridge Past, Present and Future and Coton Parish Council jointly. I'm instructed by Richard Buxton Solicitors, and I'm accompanied by Susie Gandy, who sits behind me. In terms of those people who are with me, I mean, there are various people here from the parties I've mentioned. I'm not going to mention all their names. In terms of who will be giving evidence, we have here today James Littlewood, who is the Chief Executive of CPPF. We have written to the applicant, copied 2 pins setting out who will be giving evidence on our behalf, but I can provide that separately as a list of appearances if
I think that
that's
would be helpful,
required.
just to make sure that myself and Mr. Underwood have that.
Yeah, I will do, but if I can, if you want me to just briefly run through the names.
Please.
We have Steve Johnston, who will be giving evidence in relation to transport matters. Edward Lee, L-E-I-G-H, who will also be giving evidence in relation to transport matters, principally in relation to the CPPF alternative proposal.
Yes.
We have Dominic Woodfield, who is an ecologist, who will be giving evidence in relation to the alternative. The current intention is to call Mr. Ed Pine of the Woodland Trust,
Right.
who is a separate
Mr. Parker, I didn't get the surname there.
Pine, P-Y-N-E.
Right. And he's Woodland Trust, did you say?
Yes, I'm conscious that the Woodland Trust have separately objected to
Yes,
the scheme, but in an attempt to try and be helpful, I think that the intention would be to call Mr. Pine as a witness on our behalf, but we can discuss that
Well,
if that becomes...
I certainly wouldn't want the Woodland Trust appearing twice
I
in
appreciate
different
that.
guises.
I understand
That does need to be sorted out.
Yeah, I think that may become an issue that we can talk about more generally, but for the moment, that is the intention. We then have Professor Louise Hurst, who will give evidence in relation to the applicant's carbon assessment. And as I've mentioned, James Littlewood, who will give an overarching position, including planning matters.
Yes, and just so that make sure our notes correct so far, James Littlewood, did you say he was the Chief Executive of Cambridge Past, Present and Future?
That's correct.
Yeah, good.
Thank
Does that complete your list, Mr. Parker?
It does.
Thank you. Going this way around, I've been to Miss Nevin's table. Behind Miss Nevin, the gentleman with his hand up at the end of the row, please. Oh, yeah.
Actually, there's a spare one on the back there, is there?
I think
Good morning, sir. My name is Duncan O'Connor.
So, Jonathan.
Duncan.
Sorry, Duncan.
I'm a partner at TLT, who are instructed on behalf of East West Railway Company. Objector number 247. In terms of participation today, to my left is a colleague, Jessica Hobbs. No one else is here on behalf of East West Railway Company today.
Yes.
For the inquiry, sir, we would only anticipate calling one witness, if necessary. I think it's unlikely, given that we are close to reaching an agreement with
Yes.
the applicant, but we would like to reserve our position.
Yes.
Also, sir, in respect to the specific request in your advance note, at this stage we think it's likely that East West Rail's position, in the event that agreement can't be reached, would best be dealt with through written representations, if that would be acceptable, sir.
Okay. Thank you, Mr. O'Connor. That's fine for now. Behind Mr. O'Connor, is there anybody else there who thinks they might want to speak today or at the inquiry? It's fine if you simply want to observe. There's a gentleman there with his hand up.
Good morning, sir. Good morning, everybody else in the room. My name's Rob Sadler. I represent the Sadler family who farm Madingley Hill, effectively from Madingley Mulch down to the village of Coton. I'm not a farmer myself, just as background. I'm a chartered surveyor with over 30 years' experience, and I specialise in commercial and innovation space based in Cambridge, having delivered several million square feet of science parks and innovation space across Cambridge.
Right. And are you likely to wish to speak at the inquiry itself, Mr. Sadler?
Most definitely, and also invite yourselves and your team to walk the route, either accompanied or unaccompanied, however you wish to do that.
Okay. And at the inquiry, would it simply be yourself, or are you instructing other people to appear on your behalf?
No, just me.
Thank you, Mr. Sadler. Lady next to you.
My name is Dr. Marilyn Tracy. I'm the coordinator of the Coton Busway Action Group. And
right, let me just get those details down, Ms. Tracy.
The surname Tracy is spelled T-R-E-A-C-Y.
Right. Right, so it's Dr. Marilyn Tracy, and you said you're the coordinator of the, was it Coton?
Coton Busway Action Group.
Okay.
And I will be appearing at the inquiry. There are other members of the group here today.
Yes.
We will likely have 2 or 3 speakers at the inquiry. It's not yet ascertained who will be available, as we don't know the dates.
Okay, that's fine, Dr. Tracy. I think the important thing, if any groups are intending to have more than one speaker, is to try and make sure that you divide up the subject areas, so that it's not necessary for a second or third speaker to simply repeat what the first speaker has said, but have discrete topics that you're going to address the inquiry about.
We absolutely intend to do that.
Good, excellent. Is there anybody else on that side of the room behind or next to Dr. Tracy? Yes, gentleman behind, and then we'll come to you near the window.
My name is John Green, and I wish to speak at the inquiry. I have expert experience in large projects across many sectors, and it's on that subject of governance and project management that I wish to speak.
Okay, Mr. Green, apart from your experience in that area, have you a local connection? Are you part of a group, or are you wishing to speak just as an individual?
I'm speaking as an individual. The papers which the support team circulated before this meeting
Yes.
and listed those electronically served to come, listed me as John Green, Queen's College, University of Cambridge. I do not know why they have picked that one affiliation of mine to ascribe to my name. I'm not representing Queen's College. It is one of the many honorary positions I hold, and they must have only found it by searching LinkedIn or somewhere.
Right. Are you a local resident?
I am a local resident and I live in Coton.
Right. And is it appropriate for us to mention that you're appearing in that guise as a local resident, a resident of Coton?
I'm doing it in my own personal capacity.
Thank you, Mr. Green. I think there was a gentleman near the window. Yes, the mic's going to you now.
Thank you, sir. Good morning.
Good morning.
My name is Matthew Baker.
Matthew Baker.
I am also an independent local resident, resident on the Gough estate, that's Gough, in Newnham. I probably wish to speak at the inquiry subject to availability and my personal business constraints, but
yes.
I hope to. I have particular concerns about the related to the route of the busway, in particular the routing onto Grange Road, the destruction of the Coton Orchard, the lack of consideration of alternative routes or insufficient consideration of alternative routes, and the flood risk. I guess, sir, it may be possible to coordinate some of my concerns with those of others wishing to speak, such as the Coton Busway Action Group and the gentleman who just spoke as well. Thank you, sir.
Thank you, Mr. Baker. Now, does that complete this side of the... Oh, no, there's a couple I can see.
Good morning, sir.
Good morning.
My name is Alan Tracy, also spelled T-R-E-A-C-Y, and I'm a resident of Coton, and I will wish to speak at the inquiry. I have several objections that I wish to make to this scheme.
Right. And speaking simply as a local resident?
Correct.
Thank you, Mr. Tracy. I think I saw another hand. Yes.
My name is Anna Gaisley, G-A-Z-E-L-E-Y. I am the current custodian of Coton Orchard. I also speak for Coton Orchard Limited, which is the tenant, affected tenant, and Houston Crest Properties, which owns the land, so a stakeholder. And I'm also a 30-year resident of Coton. It is my intention to speak at the inquiry, and I have had offers of expert help to speak, but whether they can come or not will depend on the dates that gets agreed later.
Yes. And, Ms. Gaisley, are you an objector as well?
Oh, most definitely.
Yeah.
It's my orchard they want to cut in half.
Yes. Okay.
Can I also put in, I officially invited you to make a site visit to the orchard, and I do so again now.
Yes.
Thank you.
I'm sure that's something that we will want to do at some stage. We would want to visit as many places along the route of the busway as we are able to do. Right, can I just... Yes.
Good morning.
Good morning.
My name is Carolyn Postgate. I wish to speak at the inquiry. I'm a resident of Coton and also a member of the Coton Busway Action Group.
Right, Ms. Postgate. We've already heard from Dr. Tracy, who's the coordinator of the action groups, so presumably you'll be liaising as to how you...
Indeed, yes. But I'm objecting on a personal level.
Of course, yes.
Yes, as
yes,
a separate thing.
Yeah.
But I may be one of the members of the group who will put forward one point
I see.
of the group objection.
Thank you.
Apologies, I forgot to add that Dr. Bridget Sutton, who's also objected, sends her apologies because she had a doctor's appointment today, but she would like to speak, and I have her written.
Is that part of your objection?
No, she's objected separately, but
Right.
knowing that I was coming today, she said she had an urgent hospital appointment.
Just give me her name again then, please.
Dr. Bridget Sutton, S-U-T-T-O-N.
And do you know in what capacity she wishes to address the inquiry? Is it as a
She's
simply
made
as an
specific
individual?
objections as herself.
As an individual then?
As an individual.
Right. Can I just check that we've covered everybody who does wish to speak on this side of the room? Right, no, okay, can we move over to the other side then? Is there anybody there who wishes to speak at the inquiry? Let's start at the back and work forwards.
Thank you. I'm Susan Buckingham. I'm representing Friends of the Cam, which is a local environmental organisation, and we're concerned with anything that affects the health of the river. And there will be two of us who will wish to object, myself, Susan Buckingham, and Tony Booth.
Tony Booth.
Yep.
Okay, thanks, Ms. Buckingham. Moving forward then. Yes, the lady in the middle.
Good morning, sir.
Good
My
morning.
name is Alison Melton.
So, Councillor?
No, my name is Alison Melton.
Sorry.
I'm Special Advisor to the Mayor of Cambridgeshire and Peterborough, and I'm here on his behalf today. The Mayor would like to attend the inquiry to make a statement. He hasn't previously submitted anything. That's because he wasn't elected until May.
Okay. And do you know what particular areas his statement is likely to cover, what his interest is in?
Well, he will be objecting, and there are a number of grounds, most of which are in the public domain already, I think. He's got concerns about environmental issues, value for money, safety, etc.
Can you just that we start to understand the structures that are involved here, Ms. Melton? Is the Mayor is the Mayor of the Combined Authority?
Correct.
Is that linked to the Greater Cambridge Partnership?
The Mayor is not. The Mayor sits on, is entitled to attend board meetings, but doesn't have any voting role within the Greater Cambridge Partnership. I think the significance of his role is that the Combined Authority is the strategic transport authority for the area, and as such, obviously, his role leading that is of significance to all transport matters in the area, including Greater Cambridge.
Okay. Thank you. Is there anybody else on that side in front? Yes.
Hi, thank you very much. Kate Fry, F-R-Y. I am representing the Gough-Way Residents Association and objecting in a personal capacity, but reserve the right to speak, but may not need to, if I've said it, or everybody's said it all already.
Yes, I think it was Mr. Baker who mentioned Gough-Way previously, so I don't know if you may be able to coordinate with him. Yeah, thank you.
My name is Keith Glover. I'm the past chair of the Gough-Way Residents Association, and also the local flood liaison volunteer. And we might wish to coordinate a little bit with the Clare Hall submission on flooding, but at the moment we have issues with regard to that. I'm an emeritus professor of engineering.
Okay. Right, thank you, Professor Glover. Certainly coordinate in terms of Gough-Way. There seem to be at least 3 of you who are involved in that area.
I should say that Gough-Way is about 150 dwellings.
Yes. Okay. The lady who's got the microphone now, please.
My name is Laura Wood, and I'm one of the partners in Ashcroft Vet Surgery in Hardwick. And we are objecting about the changes on St Neots Road, which will affect our business. Our business has been there for 40 years, and we may have to move if they take away our lay-bys. I'm also objecting generally, along with the Coton people, at the general disruption, but I am hoping to be at the inquiry, dates allowing.
Yes. Okay. Yes, please.
Hello, I'm Andrew Davidson. I'm a local resident. I'm objecting.
Which a local resident? Which area, Mr. Davidson?
I live on Goffway.
Goffway again. Yes.
And as a consultee of the consultation process, I'd like to comment on the option assessments report that was the output of that process.
Yes. Okay. Thank you, Mr. Davidson. Is there anybody else who we... Okay, thank you. So quite a number of people then who wish to participate in the inquiry, and there'll be the opportunity for liaison with the programme officers to make sure that that can be arranged. Moving down the agenda for today, I just wanted to have a word about the scope of the proposal, so that everybody, including ourselves, are aware of what is involved. The order itself, the main provisions are summarised in the covering letter, I think, that comes with the application. And paragraphs 3 and 4 of that letter set out the main provisions of the overall scheme, that there'd be a busway. Other main elements include the travel hub and park and ride at Scotland Farm, bridges, access roads, compounds. It also provides for the compulsory acquisition of land and rights which are considered to be necessary for the scheme, and then a whole series of alterations to rights of way, highways, and so on. The request for deemed planning permission for the works, in terms of what that actually involves, there's something of perhaps a paper chase, Mr. Cameron, in finding that out, because you're directed in the first instance to the order. I think Article 20, from memory, refers to the authorised works, which then you find out that you need to go to Article 2 for the scheduled works, which are then set out in Schedule 1. Basically, it's providing for the deemed planning permission for the development provided for, authorised by the order. I think it would be helpful if the applicant could set out a precise list of the development works in one place, so that we're ourselves and other parties are absolutely clear on what is the subject of that request.
Also, we will do what we can to assist, of course, and we will do that, if you'd like, in effect, cross-references to the relevant parts of the order. There is a request for deemed planning permission, which is at core document 1-14.
That's right, yes.
Which sets out the request. But so if you could tell us precisely what you'd like, we will do it.
Let me just check 114. Right, core document 114 has a very short paragraph number 3, which says that the development for which planning permission is requested is development for which provision is included in the order. So straight away you're referring back to the order. And then I think the order takes you to different places. It doesn't have one composite list. That's what I would find helpful.
So, sir, in terms of the application,
Yes.
there are drawings.
Yes, there are.
Which are referred to in paragraph 5 of core document 114.
Yes.
So it's those drawings to which the request relates, but in effect you're asking for something equivalent to a description of development by
Yes.
reference to the relevant parts of the order.
Absolutely.
And we will
Yes.
provide that for you, sir.
Yeah.
And for
Thank you.
others.
That's helpful. Thank you very much indeed. And then in terms of the third element is what's known as the Section 19 certificate in respect of the open space. And in this case, it's to do with the exchange of land, the replacement of land, which I think is required in connection with the construction of the bridge over the M11. And because of the use of that land for that purpose, there's provision being made for additional open space to be provided. Does that cover it, Mr. Cameron, in terms of those three areas?
That is right, sir, and just going to hopefully direct you, sir. There is at core document 122,
yes,
the application for the certificate, where if anybody would like to see it, it's set out. But in essence, it does relate to exchange land at the point where the proposed bridge crosses the M11.
Yes. And in the document you've mentioned, I think the relevant part for anybody going to the website to check that is to have a look at paragraphs 1.7 and 1.8. And I think those paragraphs identify the parcels of land involved.
That's correct, sir, and it's as at 1.8, as you rightly say, it says, as provided in Appendix 1, it's proposed land at, and then plots are given.
Yes.
So you can identify the precise areas of land.
I think there are 2 plots lost and 2 replacement plots from memory.
Correct, sir.
Having mentioned what the main, the 3 areas which are the provisions of the scheme are, I just wanted to move on to proposed amendments to the order, which we've been made aware of quite recently from the applicants. We've received a schedule of changes, and I just wondered, Mr. Cameron, if you could outline those. Our understanding at the moment is that those, I think there are 3 broad categories, but that they're essentially to deal with minor matters rather than changing materially any of the substantive provisions of the scheme. But Mr. Cameron, could you just address that so that people are up to speed with what the applicant is proposing?
I will, sir. And also, your programme officers have been very up to speed, because on the core documents, as of yesterday, core document 1-02A and 2B, you will find, supplied by the applicant, a copy of the proposed amended draft order. The reason there are 2 copies is because one of them has track changes so that anybody can see what the changes are that are proposed. And there's no mystery to this. They fall into 3 categories. First category is typographical errors. The second category is discrepancies with plot numbers in Schedule 9. And the third category relates to protective provisions. And in particular, protective provisions in this case, and to remove any jargon from that, those are special provisions in the order which deal with particular concerns and particular bodies and interests. So here there are protective provisions relating, and I'll just give some examples, the Environment Agency and the National Trust. And there have been changes to that element. So there's no change to the substance of the order. It's typographical, plot numbers, and some of the protective provisions. And so while I'm metaphorically on my feet, just so that everybody knows, during the course of the inquiry, or maybe even before, there may be other changes proposed. And so these changes are proposed because the Secretary of State has power to make the order with modifications, and therefore if we are promoting modifications, we put them forward so everybody's got a chance to comment on them. The other changes that may come forward are in relation to protective provisions, and it's the organisations that I've mentioned, Environment Agency and National Trust. And also you will have seen, sir, from our statement of case, and for everybody that's core document 2301 and it's paragraph 1118.3, that we raise the possibility, we don't think it's necessary, but if our argument is rejected in relation to the application of regulations relating to biodiversity net gain, we may make a request for a particular local provision in relation to biodiversity net gain. So those are anticipated changes. I raise them now. They may never happen, but then everybody's got advance warning that they might happen.
Thank you, Mr. Cameron. There were two particular points I just wanted to raise. I think it was last week we received reference to a validation process in terms of the draft order, and just wanted to clarify that because our understanding is that that is something that would happen at a later stage, post-inquiry, and that we can simply put that reference to one side.
Was this the procedural note, sir, that you're referring to?
No, there's a separate email. My note is that there was an email exchange on the 20th of June between Mrs. Vincent and Mr. Guyat. And Mr. Guyat informed Mrs. Vincent that the draft order had been run through the validation process and had passed that successfully.
So it does happen at a later stage,
yes,
because, and it happens at a later stage because further changes may be promoted.
Yes.
And this is just a preliminary.
I just want to check we can disregard that.
You can. Well, I say disregard it. You don't need to consider it at the moment.
Yes.
I think is the answer to that.
Yes. Right, we suspected that was the case, but I just wanted to be clear and make sure that everybody in the room was clear as well. And the second thing I want to check is in terms of, even though they may be detailed, just knowing what document we're referring to, we initially received notification of a suite of documents. There was the schedule of amendments, which you've been through the three categories. There was then a proposed amended version of the order, which incorporated those changes, and a track changes version, which came through so we could make the comparison and check that things were as you said. And then I think a further copy came through, which is the one that I think you mentioned that had already been uploaded to the website. That came through separately. What I want to make sure is that there aren't two slightly different versions of the proposed amendments, which could cause some confusion. Is the one that's the latest one that came through to the programme officers, which has been uploaded, the same as the one that came through earlier last week?
It should be, sir. There's no So there should be a schedule which is separate and independent,
Yes.
which explains the changes.
That's right.
Then there is a copy of the order as proposed to be amended, and then there's a further version of the order as proposed to be amended in track changes.
Yes.
And they have been uploaded to the website 1.02a and 1.02b, and those are the ones that you should have regard to.
What I'm trying to make sure is that there wasn't one set of proposed amendments partway through last week which has subsequently been superseded.
No, sir.
Just one.
Just one. Just trying to be helpful by providing track changes so everybody can see what they are.
No, that's fine, Mr. Cameron. Thank you very much. And you've mentioned, I wanted to ask about further amendments, and you've helpfully dealt with that and indicated that there may be some that do arise because of ongoing discussions and negotiations.
That's correct, sir. And they relate to protective provisions, so they are ongoing negotiations with the people who would have the benefit of the protective provisions.
Yes, that's understood. Can I just before we leave this part of the agenda, I just want to turn to a point about the statement of matters. Now, as I mentioned earlier on, the statement of matters doesn't come from the applicant. That comes from the Secretaries of State and lists a whole lot of matters that they require Mr. Underwood and myself to consider, and therefore the parties to provide evidence on. What came to light was that there is typographical error towards the end of the statement of matters. It relates to the public open space exchange, and it's in paragraphs 10 and 11 on page 3 of the statement. In paragraph, as I've already mentioned, there are two parcels of land involved each way in the exchange of open land. Paragraph 10 of the statement of matters only refers to one of them as being acquired. And in paragraph 11, in terms of the exchange land, the wrong reference is given. Now, the department has acknowledged the error and has advised that it intends to issue an amended statement of matters, which we had hoped would be available by the time of the meeting today. Nevertheless, the important thing that you need to bear in mind is that in terms of the exchange of open space land, the application itself, the book of reference which identifies the plots, and I think the reference is to pages 59, 60 and 64, and the public notice about this, they're the key documents and they are all correct. It's simply the statement of matters, and we're aware of that, but the documents concerning with the application are all correct. I don't know, Mr. Cameron, if there's anything you wish to add to that.
Nothing of substance, sir, but the application documents are correct, and the statement of matters are just the matters on which the Secretary of State particularly wishes to be informed.
That's right.
And you, sir, will have, even if the Secretary of State didn't correct it, and it's good that she or her officials are going to, you would have a duty to report on the application to the Secretary of State anyway, so it doesn't make a massive amount of difference, but it would be good to get it right.
It would, and as I've made clear, Mr. Underwood and myself are aware of which parcels of land are involved, and it's those parcels which we will be considering. Right, that deals, I think, as far as I'm concerned, with we've covered the scope of the proposals. Are there any queries about that before we move on? Good. In terms of the main considerations, we've indicated in the advance note that we think that those should reflect the statement of matters from the Secretaries of State for obvious reasons. There are a few caveats. One is the second point in the statement of matters is whether all statutory procedural requirements have been complied with. And the applicant has already put in a note to set out how those have been dealt with. And I simply wanted to ask today whether anybody has any query about the procedural arrangements, for example, the public notices, the publicity that's been given to the scheme, that whether or not that has been dealt with correctly. It's usually a very straightforward matter. The applicant will make attempts to follow the rules and the requirements. Is there anything you want to draw attention to, Mr. Cameron? Because I am aware that there was one point that you mentioned in that document about, I think, a few notices being removed a bit slightly earlier than they should have been.
Yes, sir, but where that's happened, we've referred to it. And one of the reasons why we put it in now is so that anybody who disagrees with us or has some different point of fact or some legal point has a chance to raise it, not today, but at the inquiry. And that's why we put it in advance, because what we, and no doubt you, would not want to happen is somebody raises it at the last minute. So if anybody's got any point, we've set it out. If they disagree, please could they tell us and you.
Yes. Yes, please. There's been so many new names this morning. You'll probably have to remind me of your name when you speak, please. Mr. Sadler, that's it.
We strongly believe, as one of the landowners, that the correct procedures were not followed, but this can be dealt with in the inquiry, but I just wanted to make that point.
Well, I think it would be helpful, Mr. Sadler, as you've made that allegation, just if you could just tell us which procedure you're concerned about.
I can't, because today was all about preparing for the inquiry, not necessarily to list out how the GCP have handled negotiations with landowners over the past 10 years. It's covered in a letter that has been submitted, so the detail of that has been disclosed, and we shall wait for the public inquiry to deal with it in due course.
I suspect that may be a separate point from the procedural requirements that are dealt with by Matter 2 in the Statement of Matters, but thank you for making us aware of it. Does anybody else have any queries concerning the compliance with the rules? No, thank you. In terms of other matters for consideration at the inquiry, there was a note from Clare Hall which raised some suggestions about matters that might be included. I just wanted to raise that at this stage. The first one, I think, concerned Clare Hall itself as a listed building and the heritage aspects of that. And we think that that's already there. If you look at the Statement of Matters under 4E, although that does give a particular emphasis to the American Military Cemetery at Madingley, it does talk about the effect of the scheme on heritage assets. That's not, so that consideration does not just relate to the cemetery, and we will pick up other heritage matters there. And then I think Clare Hall also had a concern about flood risk. I think we see that as being covered by 4C, because 4C is the effect on of the scheme on the environment, and then it says including, so it's not exclusively biodiversity, habitats and wildlife. And so we would be looking to bring it in there as things stand. Do you want to?
Yes, sir. If I may, the point that Clare Hall wished to raise on flood risk is in particular the requirement of the applicant to satisfy the sequential test and the exception test.
Yes.
And as you'll be aware, if neither test are satisfied, the scheme should not be permitted. So we see this as quite a fundamental question that requires separate consideration to just flood risk generally and the effect on the environment. As we understand it, paragraph 4C is looking at, as you, sir, have made clear, it's these environmental effects, and that's where the general flood risk considerations, as we understand it, may fall. But the separate issue of whether the required tests have been followed so that you can reach that conclusion, we think is a separate point and should at the very least merit being considered separately to just environmental effects.
Well, certainly the nature of the concern that Clare Hall raises will be considered. It probably boils down to where exactly we hear that evidence. But can I just ask Mr. Cameron whether he wishes to comment on what's been said, please?
So there's a distinction to be drawn between matters which are to be considered by the inquiry and those which are to be identified in a list of main considerations. And when one's drawing up a list of main considerations, they are exactly that. And so we agree with your analysis that 4C is sufficient to encompass this point, because the whole point of the policy on sequential approach exception test is to address a specific effect on the environment, namely flood risk. It's just a policy which applies to that. So it's not necessary to add to the list. And we agree with you on heritage as well, sir. I know that Clare Hall make other points. But, sir, that's not to say that those matters shouldn't be considered. They should be. It's just a question of, do you put them under the heading main considerations? No, you don't need to. You're getting down to too great a level of detail. I mean, it would be like saying on the effect of the scheme on the green belt, oh, you should put on the list, are there very special circumstances, which is the policy? No, you shouldn't, because we're dealing with main considerations. But so this is not something that we're going to take a great stand on, because these are all matters we accept which need to be considered. But if your list of main considerations adds every detail, it just gets too long and it's not effective.
Thank you, Mr. Cameron. We'll obviously consider, Ms. Bruce-Smith, what Clare Hall have said. But I think the main point to bear in mind is that certainly the concerns about flood risk will be covered. Whether or not it merits a separate heading or not is a different matter.
I'm grateful. So just a brief word of response, just to say that we understand that it may not be necessary to put on the list, but our view is that it would be helpful to... We'll
respond on this and the other 2 points, which I'm going to refer to now, in our note of the meeting today. But I think the other 2 points that Clare Hall raised, which probably aren't covered by the statement of matters, are firstly the adequacy of the environmental statement, and secondly the effect on Clare Hall as an academic research institution. Now, could you just say a few words about those, please?
Yes, sir. So in terms of the adequacy of the environmental statement, it is part of Clare Hall's case, and you'll have seen it in the statement of case, that there's a question as to whether the environment information or the statement itself is sound and adequate, particularly with respect to cultural heritage and noise impacts. And it's Clare's case that these have not been adequately addressed in the environmental information. And as you'll be aware, it is important that the Secretary of State has adequate environmental information to reach a sound decision on the likely significant effects of the scheme on the environment, and we therefore consider that the adequacy of the environmental information that you, sir, have before you is a distinct issue and therefore a main consideration for the inquiry.
Thank you. Mr. Cameron, do you want to respond, please?
Well, so you will have to consider whether the environmental statement is adequate, but I don't think you need to add it to the list of main issues. And also, if Clare Hall are running that case, perhaps they could say whether they are suggesting that there should be a request for further information from you or the Secretary of State, and if they are saying that, if they could identify the specific information, because when a matter which is subject to an environmental statement goes to an inquiry, a lot of this information can be provided in the course of evidence to the inquiry. And so it's not something that should go on the main list of main issues. It is something that you should consider. But if they are pursuing this, can I ask them, through you, to provide the precise details? And the whole point of this is to try and make sure that there's a proper assessment. It's not some kind of legal obstacle course. And if there is something which would assist the decision-making process, then we'll provide it in the evidence. But we need to be told precisely what it is that's missing. And I appreciate that there are points taken in the statement of case.
Ms. Bruce-Smith.
Yes, if it would assist you, we are happy to provide a list of the information that we see should be provided. We say this is set out in the documents that were attached to our statement of case, areas in which we say the environmental information is deficient, but we can collate that.
Yes,
for
I think
you.
it would be helpful to pull that together before we reach a clear view on your request.
Yes, sir, we can do that.
But do bear in mind that, as Mr. Cameron said, we do have to take a view on the environmental statements in any event.
Yes, sir.
Okay, but as I said, we don't intend to make a ruling on that today. That's something we will consider when we get the document that you've indicated that you'll provide, and bearing in mind the comments that we've heard from both sides today. And then there was the other point about the effect on Clare Hall itself. Now, in similar vein to the point we've made about flood risk and heritage, would the effect on Clare Hall not be covered by 4B or an extension of 4B, which is the effect on local residents, pedestrians, cyclists and motorists? In effect, it's talking about the effect on people in the area where the guided busway would go.
As it currently stands, sir, we don't see it as being covered by 4B, and this is because the point that Clare Hall are raising is the effect of the scheme on Clare Hall as a world-class academic institution, and these effects are different and distinct to, say, an effect on a local resident. While we accept that Clare Hall is comprised of residential occupation or residential areas, what we're looking at are a number of discrete issues to do with, as we say and as we set out, the functioning of Clare Hall. And to name a few, there's the issue that has been raised by Clare Hall as to the risks the scheme has to stymieing Clare Hall's plans for future development, which we say is necessary for its future economic and world-class reputation, this ability to evolve and grow, and that itself is a separate issue. And in terms, moreover, of Clare Hall's, the environment of Clare Hall as a research and residential institution, or predominantly a research-focused institution, there are particular considerations that must be had in that context to a noise-free environment. And so the point Clare Hall is making is the effect of the scheme on an institution, both in terms of its world-class reputation and also the amenity and impacts on those users, to put it that way, of Clare Hall, the researchers, and that is a distinct issue to merely the effect on residents, pedestrians, cyclists and motorists. It may be open to, sir, to add in and on
Yes.
Clare Hall, but it seems it may fit better in its own distinct category, because the nature of those impacts that you'll be considering will be quite different to just local residents generally. But I leave it to your discretion, sir, as to what you would find most useful. But our view would be as a separate, and we accept under paragraph 4 would be a good place to put it, but as a separate sub-paragraph.
Okay. Mr. Cameron, Clare Hall clearly have a concern about this, which they'll want to raise at the inquiry. The question is again about how it's dealt with and whether it's a discrete matter in its own right.
Well, you're going to consider it anyway, so
Yes.
because you're going to hear evidence on it from both sides. So
Yes.
it doesn't really matter, but if it adds to everybody's clarity and makes everybody feel that their point's going to be covered, you could add, because it seems to be a noise impact point, noise impact on Clare Hall. But it may be that it's more than noise, but it'll be for Clare Hall to develop their case.
Okay, thank you. Right, well, as I mentioned earlier, we will consider how to proceed with that, but we're aware of the concern, Ms. Smith.
Thank you, sir.
I think that covers the points that we wanted to raise in terms of the main considerations for evidence for the inquiry. Is there anything that's not on the statement of matters and that hasn't been raised so far? Yes, Mr. Parker, I think you want to raise something.
For completeness, and because it isn't covered in the statement of matters, I'm relaxed as to whether it's added to the list of main considerations. But at paragraph 7 of our statement of case, we ask you and the Secretary of State to consider whether the entirety of the works, the subject of the order, fall within the scope of the powers. And we make that point particularly by reference to the maintenance and access track. And so, as I read the list of issues, that specific issue isn't one which is covered by the list of issues. So I raise it for completeness. I don't particularly press you to add it to the list of main considerations unless you want to, but I just wanted to make sure that you and everyone was aware that that was a point that we were raising and isn't covered in the statement of matters.
Let me just be clear about the concern. As a reminder, Mr. Parker, this is to do with you said the access
the maintenance and access track which will run alongside the busway.
The area that can be used as a bridleway and cycle path.
Exactly, yeah. We ask you to consider whether that falls within the scope of the powers granted by the Act under Section 1.
And was it just that point of detail, Mr. Parker, that you wanted to draw to our attention?
Yes.
Okay, well, I've noted that. I'll just see if Mr. Cameron wants to say anything about it.
We're aware of it, sir. It's plainly set out in the CPPF statement of case.
Yes.
And we will be calling evidence on the role of the maintenance track, in particular from our engineering witness. So we're going to cover it.
Yes.
I don't think it needs to be added to the list of main issues, but I'm grateful
Again,
to
yes.
Mr. Parker for drawing attention
as
to
with
it.
Clare Hall, there'll be
But
evidence on both sides.
We know about it, and we will respond on it.
Yeah. Thank you. I didn't see any other hands other than Mr. Parker's go up, so good. The statement of matters is fairly comprehensive, so hopefully that covers the points that people are concerned about. In terms of the next item on the agenda is participation in the inquiry. Now, I think a lot of that has been anticipated when we went through who was present, when people introduced themselves today. I think the only remaining query I had was whether parties present today are aware of any other organisations or individuals who may wish to be present at the inquiry itself. I think we had one piece of information about that, but is there anybody else that you're aware of? Yeah. Good. Sorry, this gentleman over on the far side. Yes.
Good morning, sir. Just for completeness, Nick Baker from Lichfields. We are the planning consultant advising the partnership that has recently acquired and is promoting the Bourne airfield site. The partnership does not intend at this time to actively participate in the inquiry. It is supportive of the busway. But if so, there is anything we can do to assist you and the examination, either in the form of written statements, to facilitate site visits or otherwise, do let us know. We're happy to do that. Thank you.
Right. Well, certainly site visits may be relevant because the part of the route does go through the airfield. There's already been the opportunity in terms of response to the application for the order to put in supporting statements, and it's not just objectors who are able to speak at the inquiry. Parties who support the scheme may do so as well if they wish, so there'd be that opportunity for you and your organisation if you wish to appear, Mr. Baker. Can I just check? I didn't catch the name of you mentioned the partnership. What's the full name of the organisation?
It's a partnership which is a joint venture between Greycoat, Oak Tree and Homes England. And my understanding is that representations were previously submitted by R. Taylor and Sons, who were the owners of the airfield site until a couple of months ago when it was acquired by the partnership. And right, I think within their representations there is reference to the partnership taking that development forward.
Right, well, you may wish to check that with the programme officers later on to make sure they've got that. So it's the Greycoat, Oak Tree and Homes England partnership, and they are the owners of Bourne Airfield. Thank you. Right, I'd like to move on down the agenda, please, to item 5, which is the form which the inquiry should take. And first, I just wanted to check whether parties are generally content with a face-to-face event. Yeah. Okay. Ms. Nevin.
Yes, sir. Just if hybrid participation could be facilitated, we would view that as helpful.
Yes. I think that's something that we hope may be able to be arranged if the need arises. Rather, I think there is an advantage in parties being able to communicate face to face as we're doing today. But I mean, there may be occasions when perhaps something crops up or somebody isn't able to get into the inquiry venue for one reason or another. So we would hope that on those occasions something like Teams may be able to be arranged. But yes, we've got that in mind. But in terms of a face-to-face event generally for most sessions, are parties content with that?
Yes, it's our preference.
Yes. Good.
Yes, sir. Same here.
Yeah. Yes, sir.
Good. Mr. Cameron, I know that the applicant's been involved in making arrangements in terms of venues. Do you know from inquiries that you've made so far whether remote participation is something that would be able to be facilitated? We're going to be in a different venue for the inquiry. Have you had any information about that, or is that something that will come to light and you can advise the programme officers about?
So I'm not going to promise that we can do it and then find that we can't, but we're
Yes.
going to do our best to
Yes.
arrange it.
Okay, excellent. And then the various elements that would make up the inquiry in terms of the inquiry sessions themselves. I think as a starting point, we would anticipate that the majority of sessions would be conventional inquiry sessions where there's evidence in chief provided by a witness, and then there is the opportunity for questions by those parties who hold a contrary view. I think, Ms Nevins, you raised the possibility of, I hope it's you, written representations, wasn't it? Right. Sorry, this is the trouble when there's so many participants.
That's right, sir. And this is if the applicant and East West Rail can't reach agreement. The nature of the points that East West Rail would make,
East West Rail, yeah.
I think would best be dealt with. As you know, sir, often in inquiries there's a round table type session to look at the drafting of the order. I think the concerns that East West Rail would have if agreement can't be reached would best be dealt with through something akin to protective provisions or a draft planning condition, which would best be considered at those sessions. And if it was acceptable to you, sir, we think that would best be put in writing in advance of that session, so that it can be aired in advance and then discussed at that round table type session.
Right. I'd thought from your early remarks that you simply wanted to rely on written representations themselves, but you'd be content with the round table for that detailed discussion.
That's right, sir, yes. And I reiterate, my expectation is that the objection will be withdrawn in any event.
Yes.
But if it isn't, I think it would be best dealt with at that type of session. And we would put in, that drafting hasn't been put in yet, but we could put that into the inquiry.
Yes.
At the same time as submission of proofs, for example.
Yes. That sounds as though it's maybe helpful. Thank you. Any thoughts, Mr. Cameron?
Our position, sir, is formal inquiry process for everything except for conditions. We think an informal session would be sensible.
Yes.
And, as Mr. O'Connor's just referred to consider the draft order.
Yes.
And at that point, the hope is that agreement is reached on protective provisions. But, for example, if there was still something to be resolved on protective provisions, that would be best discussed in an informal roundtable session. Yes. You can't really do that through, well, you can do it through formal evidence, but not in a very helpful way.
Yes.
So that's our position, sir.
Thank you. Yeah, I think we would probably share that view, but we'll confirm that in the note of the meeting. Thank you, Mr. O'Connor. Any other thoughts on how evidence should be presented? Right. I take it from the parties are generally content with the conventional way of proceeding at inquiry. I wanted to turn to next how those inquiry sessions might actually be set out. And there's a letter which I think has been made available to other parties who've expressed an interest in the case from Womble Bond Dickinson, who are acting for the applicants. And that set out a suggestion of structure, I think, and there's a variation on that which has come from Clare Hall as well. But essentially, what Womble Bond Dickinson are suggesting is that when the inquiry opens, there's evidence provided by the applicant on the case overall. There would then be a move on to third parties raising scheme-wide objections, and then third party cite specific objections, I think in terms of the way that, as it reads, in terms the applicant's presenting its case, that the intention would be that the applicant's witnesses would only appear initially to the case as a whole, whereas Claire Hall is suggesting that they should be, in effect, appear when the detailed objections are being dealt with, so that it can be more focused, as it were, a topic session on those individual matters. Mr. Cameron, do you want to comment on the approach, please?
Yes, sir. We thought it was helpful to set it out in advance so that you had a bit of prior notice and others did. Can I just first turn back to the thinking and then go to the detail? The thinking behind it is this, that you, sir, and your colleague, Mr. Underwood, will wish to arrange an efficient process and try and avoid, so far as possible, duplication. But at the same time, you have to have a process which enables those who wish to participate to participate.
Yes.
And you will bear all that in mind. You'll also be aware, sir, and I don't think that anybody's suggesting otherwise, but for Transport and Works Act order inquiries, there's a specific provision at Rule 18.2 of the 2004 rules, which provides that the applicant has a right to begin and a right of final reply. So it's different to those who are familiar with planning inquiries. So what our thinking is this, sir, that there's a distinction to be drawn between those who make scheme-wide objections and those who have site-specific points. And often in Transport and Works Act order inquiries, one has quite a lot of site-specific points and not so many scheme-wide points. And it's in that type of case where you get the overview explanation by the acquiring authority and the applicant, not the acquiring authority, although they are the acquiring authority for compulsory purchase. So the applicant does a general introduction and then you move into the specific sessions. But this case is different in that most objectors have scheme-wide points. And I put it as scheme-wide because they say, yes, we like the general idea, or we're not opposed to the general idea of a public transport scheme, but not this one, and not on this route, and so on. Therefore, we have to have a structure which allows for that and prevents, particularly the applicant's witnesses, being recalled time and time again, because that is not an efficient use of time. And so what we're proposing, and it doesn't have to be within the specific dates that we've suggested, but just as a principle, that the applicant goes first, as they're entitled to do,
yes,
have a right to do, and that they call all, and it may be that there's some variation that can be made to this, so it's not all, but most of their witnesses, and those witnesses are cross-examined by those opposed, in particular on the scheme-wide basis. Otherwise, they're just going to be recalled each time, and it'll all start all over again. And it just would be incredibly inefficient. Now, having said that, there will be some people who are only available on certain days. But that can be dealt with by saying, well, we won't call our witness on this subject unless the particular party, if they're a significant participant, I'm not offering or suggesting this is offered to everybody, although fairness must be maintained. So some variation can be made in order to make sure people can be there. So that is in effect our block one suggestion. Then we're suggesting that after that bit, those opposed to the scheme on a scheme-wide basis, in particular CPPF, Coton Parish Council, Coton Busway Action Group and others, get a chance to call their evidence. We get a chance to cross-examine, and unless they raise something wholly unexpected or something which becomes more important than imagined, we wouldn't want to recall our witnesses at that stage, because you've heard them already and they've been cross-examined. And then our third element would be to deal with site-specific objections. So, and I take as examples, Clare Hall would be put into the category of a site-specific objection. We also have Ashcroft Vets. I appreciate Ms. Gaisley wants to say something, sir, but if I can just finish, then she can have her say. We have to get in the habit of that for the inquiry. So Ashcroft Vets are another example of a site-specific objection. And then we would wish to call our witness. So, for example, on Clare Hall, if there aren't any other issues being dealt with by, let's say, our noise witness, we just call the noise witness on the site-specific Clare Hall objection. So that's the thinking, sir. Obviously, there can be variations on this, but you do need to adopt a philosophy or thinking of how you're going to deal with it before you then start slotting everybody in. And if you look at Clare Hall's response on this, because they're the other people who've put in a view on this, they make a suggestion at the beginning of their objection, which I can't now, their letter, which I can't now find, but I'm going to do it from memory, where they make a point 1 or a point 2, Roman 1 or Roman 2. Their Roman 2 is pretty similar to our suggestion. And they're, in my submission, they're being sensible about that. And if we adopt their 2 or adapt it to our suggestion, you're going to have a sensible scheme-wide, applicant first, then others, and then some site specifics. Now, there are some more complex, which category do you put people into? For example, and Ms. Gaisley's going to say something in a moment, Coton Orchard, it's site specific in that it relates to the orchard, but it also raises some scheme-wide issues. And that kind of objection, well, a view is just going to have to be taken. Does it go into the site-specific block, or does it go into the scheme-wide block? But that's something that a judgment has to be made on. So that's the philosophy. That's the reason for putting it forward. We think it's efficient and achieves fairness. If you took some alternative approach of starting all over again with each objector, we'd be here beyond Christmas.
I think in broad terms there is a lot of similarity between what you're suggesting, Mr. Cameron, what Clare Hall is suggesting, and indeed the approach that we would expect to see, starting off with an overview and looking at the scheme as a whole, and then moving into, in effect, topic sessions on individual concerns that have been raised. If I understand what the applicant's suggesting correctly, and as a general rule you'd only want your witnesses being called in what's called block 1, aren't you inevitably in block 1 going to be straying into site specifics?
So as I said, and I gave the example of Coton Orchard, there are some points that are the scheme is made up of a number of site specifics. Yes. So of course you will, but you've got to try and make a sensible and approach to this. Otherwise, it is going to go on for an unnecessarily long time, which is undesirable. It should go on for as long as it takes to hear the evidence properly. But if all you did was at the beginning just to have an overview, then we would have to recall our witnesses every time to deal, for example, let's take an example of a scheme-wide issue. CPPF have put forward an alternative on-road scheme past the American military cemetery. That is adopted by a number of other objectors. That raises some site-specific issues, but I would suggest that it goes in the overview scheme-wide. And taking CPPF, who are represented, and they'll respond in a moment, they have limited availability, but the suggestion that I make on behalf of the applicant would allow for that. They'd have to come along and cross-examine some of our witnesses at the beginning, but we could be flexible about the days on which they are called. And then they have the chance to present their case. If you did it any other way and said, oh, no, that's a site-specific because it's on a particular part of the route, we then have to recall all our witnesses after that. It just, I think, so what I'm suggesting is that we have to adapt the process to the facts of the case. And we are making what we consider to be a pragmatic and sensible suggestion. But of course, we'll hear from others and respond to them. But we are trying to put forward something that's workable.
Yes. Thank you. Ms. Gaisley, you've wanted to say something for a little while.
Thank you, sir. I just want to put it on record that I strongly disagree with the applicant council's categorisation that most of the objections are scheme-wide. I for one, and I think of the 24,000 petitioners and the majority of the 300 objectors are very much in support of improved transport infrastructure and the connectivity between Cambourne and Cambridge. Our objection lies in that 1.5 mile, that's less than 10%, where it veers off-road. So I would say the majority of objectors, possibly more than 90%, is actually site-specific, and that site being that at 1.5 miles. So yes, that includes Coton Orchard, so my emphasis will be on Coton Orchard, but even the other points that I raise are only in its immediate vicinity where it cuts Madingley Hill in half. Thank you.
Thank you. I think I saw Mr. Sadler's hand go up as well. Mr. Sadler.
Sorry, yeah, I'm just only going to repeat what Anna said. Yes, there are some localised objectors, including the vets in Hardwick, but effectively the majority of the objectors are with the stretch between Comberton Long Road and when it hits the M11.
Okay, Mr. Sadler, thanks. Right, Ms. Bruce-Smith, do you want to go first or Mr. Parker? Doesn't matter.
Thank you, sir. Just to clarify, I think there is, as you say, a significant overlap, or at least significant agreement between ourselves and the applicant. But just to clarify our concern with the timetable as initially proposed was just we do not think that it would be efficient for you to be hearing these site-specific evidence from the applicant on site-specific matters, interspersed with scheme-wide matters, then back to site-specific matters, etc., in this first block. And there is a separate concern that if, say, evidence from the applicant was heard in relation to site-specific matters, there would, on the proposed timetable, be a significant gap between you hearing the evidence on these matters from the applicant and then potentially only a few months later hearing the evidence from from Clare Hall and other objectors. And we think that would both be not straightforward for you as inspectors to keep all those matters separate, but just inefficient and potentially lead to some unfairness, as these matters will be dealt with a significant time lapse between the two. And the second issue we had is just as objectors, we are very cost sensitive, and if in the first tranche of block 1, we had to turn up to listen to, say, days of cross-examination on one witness, which would range, as we say, between scheme-wide and site-specific. This would involve us turning up for many more days than would otherwise be needed. And it's for that reason that our main concern is with the site-specific. You could call them topics if you want, but we think those would be better dealt with all together in say, the block 3, where we'd hear the site-specific evidence from the applicant and present our own site-specific evidence. So you see that we proposed as my learned friend referred to in block 1, two alternatives: the introduction of the scheme, the proposal that the applicant introduces the scheme with the opportunity for clarificatory questions, yes, or the second approach which my learned friend has referred to in terms of just scheme-wide. And as you said, we have no strong view between those two options, but we want to reiterate that we do think the site-specific evidence from the applicant, not just on, say, noise, but on all those site-specific matters, should be heard in block 3.
Mr. Parker.
Thank you. So we have a concern about the applicant's proposal. I don't think you've referred to it. We wrote, as I say, to the applicant, copied to pins. We had understood and assumed, in accordance with previous experience, that there might be a brief overview on the part of the applicant at the outset of the inquiry.
Yes.
But then that the inquirer proceed effectively on an objector-by-objector basis, with the applicant calling its witnesses in response to points as necessary in light of the evidence raised by the objectors. And that was, as it were, our proposal to the applicant. Can I start by expressing our concerns about what the applicant is proposing? Then I'll set out what we say should be the case and why I think that would address the concerns raised by the applicant. Obviously, we're here and we hear what the applicant says about having a fair but efficient process. Obviously, we all agree with that. That's the underlying objective. No one's going to argue with that. And we're all trying to do our best. But the concern we have with the applicant's proposal is that CPPF, and CPC, which also have financial constraints and cannot simply turn up for weeks of this inquiry, cannot frankly afford to do so. The risk is that we will have to turn up on odd days throughout the opening block of the inquiry, while the applicant runs through the entirety of their list of witnesses, asking questions at that stage, which won't be efficient or cost-effective, certainly for CPPF and CPC. I think it also raises an issue about your convenience, because I'll be asking questions by reference to objections which you haven't yet heard. And so I think the process of cross-examination could take much longer than it otherwise would if I were able to ask questions by reference to objections and evidence that you'd already heard. But then we'd be turning up for several odd days during that period. We'd then have to come back at a later point in time, present our evidence, call our witnesses, and at that point, so then the cross-examination which you'd already heard might make more sense because you'd actually heard some of our evidence. And while my learned friend indicates that there's no indication or intention to call his witnesses in response to that evidence, he reserves the right to do so, and so he should. That is his right. But in my submission, there is every likelihood that he will need to at least call some of those witnesses, if not all of them, to deal with the evidence that we give. That in itself raises an issue of fairness, because the applicant will essentially having two bites at the cherry. It also raises a question about efficiency and the good use of time, because why hear them once at the beginning when, frankly, it'd be more sensible to hear them after they've heard the objection, when you and they have heard our evidence. So we respectfully would strongly push for the opportunity to cross-examine the applicant's witnesses as part of a block of us giving our evidence and then hearing from the applicant's witnesses in response to it. which in my experience would be conventional, although there are no doubt others in this room with far more experience than me to whom I will bow. But that has worked well in the past, and I would respectfully invite you to adopt that programme. The concern raised by the applicant, which is one that I absolutely understand, is will the applicant need to repeatedly call the same witness over and over again to deal with similar objections? I understand that concern. That's something to bear in mind. In my submission, that concern is in reality not going to transpire, because if one looks at the parties who want to speak, you have 3-4 parties who are represented, 2 of whom expect their objections to fall away. So there is essentially 2 represented objectors who will be presenting their own professional witnesses and presenting cases to you. All of the other people who want to speak are likely to speak in their own capacity as residents. That's not to undermine the importance of what they want to say in any way, shape or form, but the fact is they're not professionally represented or presenting professional witnesses. And so in my submission, it's appropriate to treat those people differently, those represented parties differently. And if one looks at, for example, some of the individuals whom my learned friend has indicated have adopted, for example, the CPPF alternative, we're confident that we can, as it were, organise those people in such a way that you are not going to have to hear the same witnesses over and over again once you've heard from those individuals. That's certainly the case, for example, in respect of the Cambourne busway group, for example. No doubt they will want to speak to the inquiry, but we are confident that fairness will enable the applicant to call their witnesses such as they need to in response to our case without needing to call them again by way of repetition of the points that have been made in response to individual objections who raise similar points or who adopt our submissions. And we will endeavour to ensure that that's the case if you see fit to adopt what we are proposing. Because, to repeat, I absolutely hear what Mr. Cambourne says about the need to avoid duplication, and we will do whatever we possibly can to avoid that happening, to ensure the smooth running of the inquiry. It's obviously the case that other individuals may raise other points that will necessitate the applicant calling the same witness. I appreciate that, but when everything's evened out, we have a real fear that if the applicant adopts or you adopt the applicant's proposal, that will make the inquiry unmanageable for us, and that we will not be able to participate fairly or effectively and in a way which is helpful to you. So we would strongly urge you to consider what we're saying. We obviously bear in mind it's ultimately a matter for you, and we will help you as best we can. But that is our fear. That is why we say the applicant's fears can be overcome, and that's why we would invite you to adopt the process that we're proposing for you.
Thanks, Mr. Parker. Mr. Cameron, many of the individual objections do appear to relate to the eastern end of the guided busway route. Now, although there'll be clear differences, I'm sure, in points of detail between objectors, if there were a session dealing with the stretch of the route, including Cambourne Orchard, could that not avoid the need for repeated recall of your witnesses if they came back to address grouped concerns about that part of the route, rather than being called repeatedly in respect of every individual objection, which I think is your main concern?
Well, so when I explained our thinking, I used the word scheme-wide, but I said it was unusual, and I qualified that term. And I'm grateful to Mr. Sadler and Ms. Gaisley for pointing out that the vast majority of objections coalesce around that part of the route.
Yes.
And so what I'm going to respond to Mr. Parker in a moment.
Yeah.
But the suggestion that I've made on behalf of the applicant allows those objectors to together to cross-examine the applicant's witnesses on it. I mean, whether you call the suggestion that we've made for part one is it's overall, but you including the part of the route described by Mr. Sadler and Ms. Gaisley. So you deal with all those together. Now, if we just called our witnesses at the beginning and they explained what our position was overall and weren't cross-examined, they would then have to be recalled to come back to deal with that part of the route. Because, and I'm going to deal with this in response to Mr. Parker, this is the organisation of a Transport and Works Act inquiry can take the general overview and then come down to site specifics. But that, as I said before, is when you've got really specific, in particular, landowner objections along a route. But here, you've got a coalescence of interests who object to a particular section of the route. And it's sensible to deal with all of that together. And our suggestion would do it. So that's the answer to your point, sir. But can I just respond to Mr. Parker? He made a submission which is difficult to understand, that it would be useful for you to hear the objector's evidence before hearing their cross-examination of the applicant's witnesses. Well, the whole point, sir, of this type of inquiry is applicant goes first, their witnesses, and I do remind you, sir, of Rule 18.2, unless in any particular case the inspector, with the consent of the applicant...
I've got it in front of me.
Yes, otherwise determines, just for the benefit of others, the applicant shall begin and shall have the final right of reply. Our suggestion is entirely consistent with that. We call all our witnesses not on a topic basis, because, and then everybody who is opposed to the particular part of the route that Mr. Sadler and Ms. Gaisley referred to can cross-examine our witnesses on it. They then call their evidence. We don't have to recall anybody on that basis unless there's some specific point. Going back to Mr. Parker, so he says it's better to hear the cross-examination after you've heard the objectors. Well, you could equally say, well, it's better to hear the cross-examination from the applicant of the objectors after you've heard the applicant. Somebody's got to start. And because there's written exchange of evidence, you know what their case is. So you don't, I'm not going to take the point that somebody's got to put every point of their case because it will have been written down. So that's a thoroughly bad point, sir. Now, the other problem with the CPPF suggestion is that it suggests that some priority should be given to represented applicants, represented objectors. That can't be right. Every objector must be treated equally. Some objectors cannot and aren't going to be represented. So why should the CPPF be different because they're represented? It may be that others decide to fall behind them and say, we'll rely on your cross-examination, but others might not. And why should they feel pressurized into doing that? So that is another problem with their suggestion. So, and the real problem with the CPPF suggestion is, if they're allowed to do that, why isn't every other objector allowed to do that? And if every other objector is allowed to do that, we go on and on forever. And therefore, and I'm not suggesting that any objectors here would, but it gives people a tactical opportunity to do that as well. And that needs to be prevented in a fair and sensible way. And the suggestion I've made, which is, and whether you call it scheme-wide or main issues, we call our witnesses, they're cross-examined, then all the objectors, one by one, call their witnesses, And that could be on the whole Coton Orchard part of the route. And then we come on to block 3, where we deal with the site specifics. And as I've said, I appreciate the Coton Orchards are site specific as well, but it will be dealt with under the first block or second block. And then we come on to site specifics. We deal with Clare Hall, Ashcroft Vets, and so on. Otherwise, it's going to become completely unmanageable.
I think you did say, Mr. Cameron, that there could be scope for some flexibility on behalf of the applicants in terms of availability of witnesses.
There could be, sir. And we
So do I take it that you're not ruling out that some witnesses could be recalled if we deemed that was the most appropriate way to proceed?
Yes, sir. And I'm also suggesting that if you accepted our suggestion and a particular person who wanted to cross-examine wasn't available, then we could either fit in with their programme, subject to the availability of our witnesses, or we could tender witnesses. But what I don't want to do, because it's inefficient, is to keep on having to re-tender or recall witnesses.
Yes.
Which, if Mr. Parker's suggestion was taken up, we'd have to do. Because he can't guarantee that everybody is going to fall in behind him. And why should they, if they don't want to?
What about the point, which I think it was Ms. Bruce Smith made, that if we follow the outline that the applicant set out, the objectors, whoever's questioning on behalf of objectors, whether it's themselves or advocates, would have to attend in block 1, and then they would have to reappear in block 3.
Not for site-specific objectors. I'm suggesting that we would then call our heritage witness on Clare Hall, our noise witness on Clare Hall, at the time that they appear. Just trying to draw a distinction between those who have a more, it's not necessarily scheme-wide, but a more general objection to the scheme, and those statutory objectors, if I'm not sure Clare Hall are or aren't, but but those who've got site-specific objections. Depends on whether their land's being taken, and there's a bit of an issue on that.
Right, so in effect, depending on the nature of the objection, you're actually suggesting a mix of when you call your witnesses, some in block 1 and some in block 3.
And so, and that's what we said in the letter. If it isn't clear, I'll make it clear now, but that's, so what we're saying is if it's a site-specific point, then we'll call our site-specific witness. But if it's a more general point, we'll call them in the first bit. But we're not expecting Clare Hall to have to come along to every bit of the first part. We're not expecting those who are opposed to the bit that's proposed to go through Coton Orchard and vicinity to come along when Clare Hall are presenting their objection.
Well, isn't your concern that some of your witnesses may be related to both site-specific and busway-wide points?
Some, sir, but in the main, we can deal with that by having, I mean, there are some who are site-specific.
Yes.
And it may be that we do have to show some flexibility, tender somebody for the site-specifics. But we do need some clear distinction between the broader objections and the site-specific objections.
Yes, I understand. I understand the points you raise, Mr. Cameron, and also those raised by other parties as well. Mr. Parker, you wanted to say something else, I think.
Yes, I'm not going to repeat myself. I just want to come back on a couple of things that Mr. Cameron said. Firstly, he said my suggestion was difficult to understand. Just to be clear, my suggestion as to how the inquiry should be programmed is entirely consistent with Rule 18. The applicant would go first, would present an overview of the scheme in a conventional way. It would have the right of final reply having heard the objections. So I'm not quite sure why it was difficult to understand, but it's entirely consistent with Rule 18 in any event. Secondly, he suggested that I had suggested that some priority be given to represented applicants. That's a mischaracterisation of what I said. That's not what I said at all. I'm not going to repeat what I did say. Thirdly, my suggestion as to the programme in my submission is not a thoroughly bad one, as he pejoratively liked to describe it. It's an attempt to be both fair and efficient, and I would simply endorse what you had said and suggested by way of response, that those objections could be grouped in such a way that the applicant could then call whatever witnesses they wanted in a single block, probably within a day, to respond to a grouped collection of objections as necessary to avoid the need and his fear that he's going to have to repeatedly call witnesses in response to a series of individual objections. Your suggestion, in my respectful submission, was a very sensible one, which would obviously avoid the concern that he had raised. And it's apparent that witnesses are going to need to be called twice in relation to scheme-wide objections, and then again in relation to site-specific objections. If that, as it were, level of flexibility can be exercised, there's absolutely no reason why, insofar as necessary, they couldn't be called again in relation to a group concern, as you have suggested. So there's nothing unworkable, and it would require very little additional flexibility on his party's part to make those arrangements work, which in my submission would be far fairer and more effective.
Thanks, Mr. Parker. I think Mr. Underwood and I are going to have to give some thought to this and come back to you. You're not going to get an immediate response, but can I just check whether there are any other points about the general structure and sequence of events at the inquiry that we need to take into account when we're thinking about it? Oh, that's good. Final question then, Mr. Cameron, for you. As I say, I understand the concerns you've raised. If we took a different view in any respect, does that cause problems of availability? Or are people available for a different block than you perhaps currently envisage?
Well, so we have provided to the programme officers availability of our witnesses, so you have that for you to consider. On availability, you've got that. There's a particular witness who has limited availability, and that's Peter Freeman of the Cambridge Growth Company, who we would want to call on day 2, I think it is, but it's on the... but that would fit in with everybody's suggestions anyway.
Yes.
So I don't think that's a problem. And I know that Mr. Kelly of the, and I think Ms. Nevin's about to mention it, of the South Cambridgeshire Shared Planning, the Cambridgeshire Shared Planning Service has availability in week 1, and we're very happy to fit in with that, and suggested that perhaps his evidence comes on the Friday of the first week, which gives us enough time to call other evidence. But I am extremely concerned that we have an efficient use of inquiry time. And we've all got to cooperate to achieve this, and help you, sir, to do this. The danger with the suggestions that are being made is that we're going to just double up, because we'll have to call our overview witnesses, they won't be cross-examined, and then we will tender them again for lots of different objectors. And the good thing about it being videoed is that people can see what's been asked before, but even having seen that, it's very difficult for somebody who's going to come along and cross-examine not to duplicate what's happened before, whereas if you get every whole series of cross-examinations, you can reduce the temptation to do that. And my response to Mr. Parker was not on Rule 18.2. It was on the idea that it's difficult to follow cross-examination if you haven't heard that party's witness call first. That's an inevitable consequence of the action. Somebody has to go first.
Okay, right. Understood. We'll take on board the various points that have been raised. We're obviously very keen to avoid duplication ourselves and to ensure that the inquiry proceeds as efficiently as possible. Did you want to? Yeah.
Yes, Mr. Cameron has already helpfully raised it, but just so that you have Mr. Kelly's dates to avoid, he's unavailable from the 19th of September until the 10th of October, and we're happy to agree with that suggestion that he could be called on the Friday of the first week.
Friday of the first week. Yeah.
Thank you.
Okay, Ms. Nevin, noted. Thank you. Right, we'll leave that with us and we'll respond as quickly as we can on this point because obviously it's crucial to how things proceed. We did have a separate item on timetable, which I think we can probably deal with fairly briefly. It's just to make sure that everybody's aware of the various blocks of time that have been set aside. The current scheduling of the inquiry is for an overall period of 8 weeks in 3 blocks, which run from an inquiry opening on the 16th of September and running through for 3 weeks until the 3rd of October, then leaving a gap of a non-sitting week, resuming from the 14th to the 24th of October, and finally after a week's gap then, sitting in November from the 4th to the 21st. Now, apart from the detailed points that have been raised, those 3 blocks of time, can people generally cope with those and make themselves available within that period to present their cases?
As far as the applicant's concerned, we can. Yeah. Sir, can I just check so that I don't miss something out? When we're dealing with timetable, are we also dealing with timetable for submission of proofs of evidence and so on, or are you dealing with that under documentation?
That's item 8.
Thanks.
Yeah. And any particular problems that we need to be aware of from anybody else? We know about the applicant.
We have provided a schedule of availability.
Okay, if it's with the programme officers, that's fine.
Yeah.
And I've got Ms. Nevin's point already, so thank you. And the programme officers will be responsible for drawing up a detailed timetable in due course. One of the things, I appreciate it's always difficult to do this, but we will be looking for some estimates of timings. So we'd ask parties to give thought to that. So cross-examination, we understand clearly that can be difficult, but certainly give some thought to the amount of time you require for your own witnesses to present their cases. Yes, Ms.
Sorry, sir, just in relation to availability, we can get a schedule over to your programme officers from Clare Hall. You don't currently have that before you.
Thank you.
Just to let you know.
Yeah. Good. Just a word next about the inquiry venues. For the most part, the inquiry is going to be held in Cambourne at the Belfry Hotel, and I understand that's been booked for all of the inquiry except for the very last day, the 21st of November, when the inquiry will move to South Cambridgeshire Hall, also in Cambourne. I just wanted to, Mr. Cameron, as I understand it, the applicant's been responsible for making venue arrangements. I just wanted to check that there will be all the usual facilities available at both those venues in terms of retiring rooms, Wi-Fi, secure document storage over the weekends and so on.
Well, as I said before, I'm not going to promise something without checking, but unless I'm told Otherwise,
I can see nods from your team.
Well, there we go.
Yeah.
That's more effective than me saying anything.
Yeah.
So, nodded.
Okay, good. Let's move on then to... Sorry, yes.
Could we get a microphone?
Yeah, can we just get the microphone? Thanks, Jeff.
Yeah, could I just firstly introduce myself? I'm Mark Abbott, Chair of Coton Parish Council. I apologise because this procedurally is not correct, but I'd like to go back to the running order and just, if I may, counter a point made by counsel for the applicant. I think it would be incorrect to characterise the CPPF and CPC representation as, if you like, two bodies, but rather representing 24,000 people who signed a petition and the hundreds and hundreds of people who have contributed financially to raising the funds for us to, as a group, represent those people by paying for counsel, lawyers, transport consultants, environmental consultants. It is, in my view, not fair if the running order is stacked towards the order proposed by the applicant, and those people are not heard because we run out of resources. We simply can't afford, for the format of the hearing, to take the form proposed by counsel for the applicant.
Okay, Mr. Abbott, thank you. Yeah. As I said before, we'll take all points that have been raised into consideration. Thanks. Yeah. Just going on then to item 8 and the documentation that's needed in association with the inquiry. There is an inquiry website which has been set up by the programme officers. Hopefully parties have been able to get access to that. If there are any difficulties, please see Mrs. Vincent and Mr. Taplin about that. That includes the core document library, which is subdivided into a series of sections. If there are suggestions for any further core documents that are going to be referred to that aren't already on there, again, please liaise with the programme officers about that. And in mentioning core documents, there can often be an overlap between what parties put in to accompany their proofs of evidence and what's being held as core documents. If something is already there, there's absolutely no need to repeat it subsequently when proofs of evidence come in. It only needs to be in one place. I wanted to say a word about statements of common ground. This is something which was also in the letter from on behalf of the applicant last week. I think it's 8.1 of the letter. And I think there's a suggestion, Mr. Cameron, that the applicant's willing to enter into a series of statements of common ground with a number of parties. I think 13 parties altogether. And I think we would encourage that. It's helpful to have agreements set out and narrowing the points of difference between the parties, so that if those are in mind, please proceed on that basis.
Thank you, sir. And if anybody else wants to enter into a statement of common ground, we're not saying just those parties, but again, we have to concentrate resources.
Of course.
And we've sought to identify parties such as Cambridge Past, Present and Future and Coton Parish Council, the Busway Action Group and so on, and Houston Crest Properties and Goffway residents, who appear to cover a range of different views.
Yes. Yeah. Ms. Gaisley.
Thank you, sir. I just want to say how surprised I was to see my company on the list of Statement of Common Ground, because so far there is absolutely no common ground, and being told that disagreeing is a statement of common ground was also quite a surprise. And maybe I'll pass the mic to a couple of other people that was on that list, just so that you know that we're not in discussion of any kind of common ground, because there is none.
But can I make the position plain? What we just say in the letter, those are the parties who, as you've said, sir, in 8.1, is willing to enter into, subject to the relevant third parties agreement. It's not saying anybody hasn't, we're just saying the door is open.
I think, go on.
I think it's worth saying that statements of common ground aren't something where you sort of just sort of set out to disagree. We find them very helpful. It doesn't actually change the parties' positions, but what it can be helpful to do is understand actually are there specific facts that are agreed. We understand that obviously parties are going to have very different positions in terms of their views on it, and also a statement that actually is very clear about what the areas of disagreement are is as helpful as the areas that are in disagreement. So just to say that from myself and Mr. Clegg's point of view, statements of common ground, including that clear sort of setting out of where there aren't areas of disagreement, is really, really helpful. I'm conscious that groups, especially those who've perhaps been expressing concerns about a project for some time, you're clear about where you disagree with things, but for us it's probably quite helpful to have that set out. So I would encourage, if parties are willing to enter into statements of common ground, including that setting out of areas of disagreement, that can be very helpful for us.
I completely understand where you're coming from. I just wanted to point out that as I'm a layman, I have no experience with these sorts of planning situations, so do forgive me. But when I just saw that list on just before the weekend, I was like, huh, what? As a layman, you see that, as certainly some of the people in the village approach me, so, oh, are you working things out with them then? Are you now in agreement? Are you now not objecting? Which is the perception, I as a layman got. That's just why I wanted to point out that list to lay people like myself. It seems like agreements are being made where Houston Crest Properties, which is just my family property company that owns the Coton Orchard, we're not in any negotiations. There is no good faith between ourselves and GCP anymore. We've had 10 years of bullying, so
well,
I've explained. I just wanted to put that across. Thank you.
I've explained what a statement of common ground is and what it isn't, and that they can be helpful even on areas where there's a great deal of disagreement, just to perhaps confirm certain facts. If parties don't enter into them, it's not something that we enforce, but it's something that we can find helpful.
Could I ask you, is it written, the Statement of Common Ground, anywhere? And if so, where would we find it? Yes.
I mean, a Statement of Common Ground is written. The applicant has stated they're willing to enter into them. Statements of Common Ground are quite common in planning inquiries. There are, I think, sort of particular formats for them. Does that answer your question, or were you saying where?
No, not really. I would like to see them. And would they be in the documents on the website?
None have been provided yet. The applicant has set out in their letter they are willing to enter into some statements of common ground. None exist. When those that are prepared would become part of the core documents that you'd be able to see on the on the website. So you haven't missed anything, because they haven't been written yet. The applicant was just saying they're willing to do so.
Right. Thank you. Thank you.
Yes. All we're saying is we understand they don't exist. Is that we know the applicant's willing to do it, but it depends on the other parties. We'd encourage it. It's, as Mr. Underwood said, there are often points, maybe factual points, background points, where, and if they're not in statements of common ground, they may well come out in questions from ourselves when the inquiry gets underway. So if there are baseline points that are clear and obvious, simply relating to matters on the ground, which would aid our understanding of the situation, we'd strongly encourage parties to do it. I wanted to move on from statements of common ground to just some additional documentation that we've been made aware of. The applicants refer to a number of things. Firstly, to an addendum to the environmental statement concerning its coat and orchard trees. These were referred to in a letter last week. An engineering assessment of alternatives that's being produced, and a technical note as well to do with financing. And the question was in terms, I think that was aired, Mr. Cameron, was about notification of these, and you were concerned that it was done in a proportionate way.
So can I explain? On the, again, overview, some of these documents we could have produced, or some of this information, as part of our proofs of evidence and sent out in accordance with the programme, and then people would have got them, subject to your decision on timing, but in accordance with the rules, 4 weeks before the inquiry. Having seen, and I just take as an example, CPPF, in their statement of case, they append a document on alternatives. They've kindly provided that in advance, setting out their case, and we thought it would be useful to set out our engineering assessment of that, and do so in advance of the time when CPPF and others prepare their proofs of evidence, because otherwise what happens is we just put it in our proof of evidence. They've got a very short time to prepare a rebuttal. So this is to give people advance notice of matters which we considered are likely to be highly pertinent to your the issues that you consider and report on. So that's the reason for doing this, and we say we're going to do it, and telling everybody we're going to do it by not later than, and we hope earlier than, the 22nd of July 2025, and we're hoping that this would give those who receive it a little bit of time to consider before they finalise their proofs. On the tag technical note, so that's transport analysis guidance put out by the Department for Transport. In May 2025, the Department for Transport issued a new value for money framework, and there are various additions to the transport analysis guidance. And again, we're going to planning to do an update on the position on that, and rather than just providing it in a proof of evidence, going to do it in advance to make it, give people advance notice. On the ES addendum, that is voluntary further environmental information. There's been a further survey of trees in Coton Orchard. The tree expert has formed a view. This leads to a different basis for analysis, not a different outcome, in that there are no new likely significant effects, but it's an updated assessment, and the applicant will now present evidence on the basis that trees T2 to T13 are veteran trees. And so what we intend to do, sir, is to publish the ES addendum. It says in 9.4 will be made available on the inquiry website and has been electronically served on parties who've submitted a statement of case by the same time as the letter, and it says the applicant does not consider it necessary or proportionate to serve the ES addendum on all parties referred to in the book of reference. And we're asking, sir, if you'd be grateful if you could confirm agreement to the approach. And the reason for that is it'll be on the website and available to people and save an awful lot of paper.
I think to an extent,
that's the position,
yes.
sir.
I think broadly that seems a reasonable approach, in that people can have access to it on the website. I think 2 points. First, there are a couple of documents not available yet, but towards the end of July. So you've got the 3 sets of documents that should all be available by then, plus a possible series of amendments to the draft order, which I think might be coming along depending on how negotiations go. I think you anticipated that there might be another...
So I'm not sure that will be within the same time scale,
well,
and that's why we've published the updated draft order now so that people have got it.
Certainly on the website, I think in terms of them being accessible, that should be fine, and then parties who are aware of that can take those into account as they prepare further documentation. I think what we would also like, because the information is different, there's always the possibility that somebody may feel they're affected by a change who is not on the initial circulation list, for example, the people who've already served a statement of case. So I think we may suggest that the programme officers do a general circulation of respondents to the application to make sure that there is a wider awareness of the changes. And the other suggestion is about the possibility of publishing a local notice to cover the updates.
So, Sarah, as I understand it, the programme officers will then have a general circulation to all respondents to the application.
Yes, just as I've done with the arrangements for today.
Yes.
Just drawing their attention to it.
Well, that sounds very sensible, sir. And on the notice, you are anticipating that the applicant would ensure that a notice is published in the newspaper, but that would be presumably just in relation to the ES addendum, because we can't do that, or I suggest that it would be impractical to do that with each new document, because these other documents are just early release, in effect, of what would otherwise be in the proof.
But I'm just thinking of fairness. I want to make sure that everybody's aware of the documentation that's coming in early. You don't need to do it now, just because the ES addendum is the only one I think that's available now. If you're going to do it for that, and you do it at the end of July, why not include all 3?
We can do that, sir, and perhaps also, I'd also suggest that in that notice it says, and this is all available on the inquiry website, and here's how you get to the inquiry website, and please, but I'm just have a slight, we can certainly do that, sir, but I have a slight hesitation of newspaper notice being published for these particular documents and not for some other document that goes on, and whether if we create some precedent that we're going to publish a newspaper notice for a document. I can, for the ES addendum, which is voluntary provision of further environmental, what would otherwise be further environmental information, I can see that's a good idea, but I am hesitant about publishing on the other documents, because does that mean that everybody expects a newspaper notice every time a document is added to the inquiry website? Because if it does, it's going to cause a very heavy administrative burden.
No, we're not suggesting that. It's simply that you're already aware of 3 documents that you wish to add on in support of your case. They're available at a similar time. It seems sensible to pick them all up. The other alternative may simply be to refers specifically to the ES addendum, to draw the attention of parties to the core document website and to advise them to check for any updates in terms of added documents on there.
I think that would be the wiser course of action, sir.
Mr. Parker, did you want to come in?
Just very briefly, given that the two of the documents at least appear to relate directly to the CPPFL case. First, I hear what Ms. Cameron says about early provision of these documents. On the first one, however, the engineering assessment, it's suggested that the findings of the assessment are known because its conclusions are stated in the paragraph in the letter. Yes. But that the copy of the assessment will only be submitted to the inquiry by the 22nd of July 2025. Obviously, the CPPF alternative scheme has been available in the public domain for a very considerable amount of time. A version of it was appended to the statement of case. While I hear what Mr. Cameron says about advance warning of things that could be in the proof, if it's only published on the 22nd of July, in reality, given the summer period, it's going to give my witnesses limited time to review it. And so I would just ask, if it is available, that it be provided sooner rather than later. That said, the CPPF will be producing its own evidence in relation to these matters as part of its proofs of evidence. But insofar as the intention is to avoid rebuttal proofs and further responses in due course, I would just ask that it's provided as soon as possible, because my witnesses are in the process of preparing their proofs of evidence, and it may become too late if that's its intention, if it only gets to us by the end of July, frankly.
Go on, Mr. Cameron.
Well, when I introduced this, I did say, and before, if possible, and I stand by that, we will produce it before. I mean, and I anticipate that CPPF will have it well before the 22nd of July. I hear the point. It's responding to the April 2025 document. Yeah. And I don't anticipate it will prevent the need for rebuttal proofs, but it should reduce them. So it is genuinely trying to be helpful, and we will try and produce it sooner. So I hear and respond positively to what Mr. Parker has said.
I'm grateful for that. The second document then,
the technical note. Yes,
a tagged technical note. Refers to the new May 2025 guidance and updates the transport analysis guidance, which is fine. And then the letter, the third sentence says, in addition, certain parties have commented that assessments for the scheme have not taken account of changes in transport movements following the COVID-19 pandemic or the resulting effect on scheme benefits. I mean, that's a point that's squarely taken by CPPF. It's one of its main points, that the underlying assessments are not sufficiently up to date. I flag up a concern, which is that responding to new guidance is one thing, but providing new baseline transport assessment data is a completely different kettle of fish. And that if a considerable amount of new transport and traffic data is going to be provided on the 22nd of July 2025, that again is going to make things difficult for my witnesses. So I don't know what is underlying that third sentence of that letter, but I raise a concern now about what is to be provided and the fairness of providing, which in my respectful submission it does not fall into that category of information which could legitimately come forward as a proof of evidence. If it's new baseline information, then it shouldn't be being produced at the proof of evidence stage. It should have been produced long ago, at the very latest with the statement of case, if not before. So I just want to put a note down
Yeah.
in that respect, because otherwise that's going to cause difficulties in terms of the preparation of evidence.
Mr. Cameron, have you anything
well,
to...
it's something that they're getting earlier than they otherwise would do. So seems a bit harsh on us to complain about it. If they want it with the proofs, we'll give it to them with the proofs. But we're trying to assist, and we are responding to a point made in the statement of case. And that's part of the process. But so I don't think it's going to be very helpful. If we'll do it earlier if we can.
Yeah,
So
I understand that this document is simply not available yet.
I understand that. Just to make 2 points. Firstly, this is a concern which was raised in the objection way before the statement of case. And secondly, to reiterate, this is not, in my submission, evidence which could ordinarily or legitimately come forward in the proof of evidence if it is essentially baseline transport assessment data. That is not the evidence, that is not the type of evidence which the applicant can legitimately produce and adduce in a proof of evidence. It's data and assessment which the proofs of evidence, both ours and the applicant's, should be commenting on. And the question is, if a considerable amount of new data, underlying baseline data, is produced shortly before the deadline for proofs, where there's going to be the fair opportunity for doing that. So I do come back firmly to Mr. Cameron's suggestion that he is conferring some advantage on us by not producing this evidence with the proofs of evidence. It's not that type of information with respect to... So I just want to reiterate that point.
Yeah. Noted, Mr. Parker. Mr. Cameron, can you...
I don't think there's anything to
add.
Usefully add, sir. It's interesting that Mr. Parker seems to have quite an insight from that it's baseline data. So
the point is, I don't know.
Yes.
And that's my concern.
You'll find out when you get it.
Okay, we're not going to get any further with that. Mr. Smith.
Sir, it's just a practical point. I just note the time, and I was wondering whether it'd be possible to have a short comfort break if that would be possible.
Yes, certainly content to do that. Yeah, it's about 25 to 1. So, yeah, we'll take a short break and back to. It shouldn't take long to finish things off, but we'll break now and resume at 1:45.
Thank you, sir.
Jeff, in terms of proofs, we said we'd get hard copies. Are you happy for appendices to be electronic?
Yes.
Yeah.
Yeah, but I prefer a hard copy proof just so I can
Yes, I would.
scribble on it.
And should we get? Do you want a hard copy of the land and works plans as well, even though it's a smaller scale?
Yeah, probably be helpful. Actually.
Yeah.
Yes. Yeah. Although actually,
The BA.
the land plans.
That's those. They are.
I'm less worried myself, but
Yeah.
if you want them, we'll both get them just to make it.
I'm happy with an A3, I think.
Yeah.
And
Oh no, yes, yeah. It's just because it's if I can't read number, it's easy just to look it up on the screen. So I'm less worried about the land plans.
Could you all take your seats, please? It's time for us to resume.
Is that switched on?
Should be. I've slid that thing. Can you, just a reminder, can you take your seats, please, and then we'll get underway. Thank you. We're on item 8 on the agenda, just dealing with a few other points and documents. And I've been advised by the programme officers during the adjournment that the Department for Transport has now reissued the Statement of Matters. And I think it will shortly, if it's not already there, it will shortly be on the inquiry website. So it's just a few other points then. The next one is possible conditions in relation to the request for deemed planning permission. And the document which includes the request, CD 114, refers to possible conditions, but then there's also a reference, Mr. Cameron, to this in, I think in section 7, para 7.4 of the letter from last week. So is the suggestion now that will be an update to the original list and that will be superseded?
Well, so what it says in the letter is that there are continuing discussions with the Greater Cambridge Shared Planning Services in order to seek to reach agreement with them on the conditions. And if those discussions result in changes to the conditions, which we anticipate may be the case, then the list of suggested conditions, and they're no more than a suggestions, will be put before the inquiry. So it is anticipated that there will be some changes as a result of those discussions.
Well, it says there will be a new list. It says once these conditions are in agreed form, the applicant will submit these to the inquiry.
And we will, sir.
So there will be an updated list.
Yes, sir.
Yeah. And in addition to the shared planning services, it may be useful if consideration can be given to possible conditions if it's possible to pursue any statements of common ground.
Well, yes, sir. If there is then agreement on some condition to deal with a particular issue or matter of concern, then that can be recorded in a statement of common ground if common ground is reached on it.
Yes. In terms of proofs of evidence for the inquiry, those working backwards from the date of the inquiry, those should be submitted to the programme officers by the 19th of August. It's my calculation. I think electronic exchange would be acceptable, as has been suggested, but what we would say is that not simply to the programme officer, but if that could be sent, they could be sent to other parties in accordance with Rule 14.1.
So we wouldn't. So I suppose the suggestion we made was that everybody sent them into the programme officer, and then they appeared on the website, so
Yes.
everybody could
I think you were concerned
get
about
them.
paper consumption, and we're certainly not
Yes.
suggesting that you send in.
But it's just so if we then send it to, if we have the obligation to serve, so I'm looking at Rule 16, in fact, sir. I
Yes.
think proofs of evidence. A person entitled to appear at an inquiry proposes to give or call another person to give evidence. The inquiry shall send to the inspector. So that will be to the programme officer. And then the proof and summary shall be sent to the inspector not later than, and that's the 4 weeks.
That's right. And then you move down to 16.4, which refers you to 14.1.
Yes, yes, sir. So we, if you require us to, we'll serve those people electronically.
Yes.
It's just we had anticipated that it might be sufficient to send it to the programme officer, but we will send it in accordance with that rule.
I think that's probably the safer course of action.
Yes. Thank you, sir.
And although we're not specifically encouraging rebuttals, but they can be useful, notwithstanding the early submission of documentation that we were talking about earlier today. And I think it would be useful if there are going to be rebuttals, it would be far preferable to have those in advance, even if it's only a fairly short period, rather than produced at the inquiry itself. I think we would suggest that given the need to digest information that comes in proofs, I know you've suggested, Mr. Cameron, I think 2 weeks ahead, on the 2nd of September. I've often found that 1 week may work better in terms of getting the documentation together. I don't think we've got any strong feelings, but I'm quite happy to take soundings from the parties on that.
By 1 week, you mean
The
1
ninth.
week before,
Yes,
so that you've got
I'm
3
working
weeks.
backwards from the 16th of September in every case.
I think I haven't taken instructions on it, but that seems sensible to me, sir, to give a bit more time, because
Yes.
then you get more useful rebuttals.
Well, that's my thought.
And certainly for us, we're going to be considering more proofs than others, because, and so I would, I'd welcome that.
Mr. Parker, you happy with that?
Yes, sorry, would welcome
And Ms.
it.
Brisplith?
Yes, same.
Ms. Nevin?
Yes, sir, thank you.
Okay, well, let's go for that then. Rebuttals by the 9th, and hopefully that will take account of points that you're concerned about that have been raised by other parties.
So just on proofs, I'm sure all those here and representative will submit their proofs 4 weeks in advance. When the special advisor to the mayor said that the mayor of the combined Peterborough and Cambridge mayor is planning to make a statement, I'm assuming that a proof will be served in accordance with the timetable.
Well, that's the expectation of anybody who's appearing
Good.
with the
Thank you,
documentation, whether they call it a statement or a proof of evidence. Their representation in personal form at the inquiry should be preceded by documents 4 weeks ahead.
Thank you, sir.
And Ms. Melton's nodding. So, I think the other point that we wanted to raise was mentioned in the advance note, and that was that Mr. Underwood and I would find it extremely helpful to have certain things in hard copy format. Specifically at this stage, copies of proofs, not the appendices which may well accompany them, but proofs themselves. And that would go for all parties who are putting in a document, whether it's an individual or the applicant or another local authority. And in addition to the proofs, plans, a note about certain plans. They can be quite there's quite a lot of detail, and at the scales that we've got them at the moment, it can be difficult in some cases. I think what we would ask for at the moment is particularly the plans relating to the request for deemed planning permission. And obviously we'd like a set each of the scheme location plan, which I think is CD 116.1, and then the proposed site plans at CD 116.4. Now I think those are A1 drawings. Now they can be, if you can, is it possible to produce as a set each at A1 so that we...
I'm sure it will be, sir.
Mr. Underwood's managed to get himself a set of A3 which are handy on site. I haven't. So if you can get me a set of A3, I'd appreciate that.
That's of CD 16.1 and 16.4.
Yes.
So one set of A3 and 2 lots of A1.
Please. And then plans of the structures at 16.6. Let's make sure we can see the bridge details and so on. And I think the compounds at 16.7. I don't think they need to be full size. They're larger than A3.
So 16.7 you'd like A3 or larger, A4?
I think A3 would be helpful
A3.
As a minimum size.
And structures you'd like the full size?
You'll have to remind me what size the full size is.
Well, I'll have to ask. Whatever they, so we will provide them in the size that they come, so that they're easier to read.
Okay, thank you. I think that covers it on documents for. Sorry, Jeff. Of course, yes, yeah. Mr. Underwood's just reminded me that there is a point just to tell you about in terms of supporting documentation, which sometimes can be sent to us in the form of links to documents elsewhere. That we don't really want that at all in terms of appendices. If you've got a supporting document, please make it available in a PDF format. Links can be notorious for changing, and we can't be certain that when we're reviewing evidence sometime afterwards that it's exactly the same as the document that you intended us to see. So we don't want live links. Okay. Has anybody got any queries about documentation? Good. Can we move on?
So the only thing is time for submission of statements of common ground.
Yes.
The rules say 4 weeks before the inquiry, but sometimes they take longer to reach agreement and they're worth having anyway. But when would you like statements of common ground apart from yesterday?
Well, yes, I was working in the other direction with you saying it may take longer than proofs. I mean, I think the whole intention of statements of common ground is get them sorted out first, then you can concentrate on what's left. So I was going to come to this, and I was going to try and encourage parties who may be prepared to proceed with statements of common ground to get them in advance of proofs. And for starters, I was going to suggest the 29th of July, which I think you'll find is 3 weeks before the 4-week deadline for proofs.
What I'm going to do, sir, is to make a suggestion that would those who are prepared, I mean, it depends on the content, prepared to contemplate a statement of common ground, notify the applicant, and then we can start preparing a draft. But I think it's only worth us starting and doing the work on preparing a draft if somebody notifies us that they're prepared to. And we've set out an initial list.
Yes.
And if they could do that within a week, then we can start work on it.
I mean, I think certainly as a backstop, I wouldn't really want them later than proofs, as the rules apply. If they can come in earlier, so much the better. Can we move on then to site visits, which is something else that's been raised in advance? I think it's section 5 of the letter that came in last week. Firstly, I should say that the two of us have already been out along the route yesterday. We haven't, there's obviously a lot we haven't seen, but we just wanted to get an understanding of the relationship in general terms of the route between Cambourne and Cambridge to matters that we've read about so far. So we've got a general idea, but we do need to see it in more detail, and there will be a full programme of site visits. This would normally be towards the end of the inquiry. I got the impression from the Womble Bond Dickinson letter, Mr. Cameron, that there was a suggestion that there was an implication about it being at a different stage than we'd normally take it. One thing we did want to air today was whether there is an advantage, particularly given some areas we simply wouldn't be able to get to yesterday, because obviously areas of private land, whether there's given the evidence that some of the evidence which we might hear at an early stage, whether there's an advantage in doing an early programme of site visits. And we'd just like to get responses to that.
It's a matter for you, but it seems to me, if I was sitting in your shoes, I'd want to go and see some of this before hearing some of the evidence, and probably to go back and have another look afterwards.
Yes. Those are our thoughts.
And we've just made a suggestion on a site visit map, but others will have other suggestions. But you have to start somewhere. So we've made this suggestion, and in fact, we would welcome, taking as an example, and it could be other parties, but let's say CPPF and Coton Parish Council had a chance to see it, and we'd welcome their views on whether you should be going somewhere else. Clare Hall is going to be a local visit. You might want to do that on a different day. We're open to those suggestions. And of course, Coton Orchard, it all depends on permission being given by Ms. Gaisley and her companies.
Of course, yes.
And any other private land.
Yeah.
So we would also welcome either pre-inquiry site visit, or, as you are aware, our objection is site-specific. So if you are breaking it up into blocks, then the site-specific block. And we would encourage the inspectors to visit Clare Hall on an accompanied site visit, and in particular because there are areas which are not accessible to the public.
Yes.
We think that would be helpful before hearing the evidence in relation to Clare Hall.
I think that's the view that we share, that we'd feel that there'd be a benefit in having either one early programme of site visits or perhaps split, as has been mentioned. But I think we'd also need to come back at the end, probably before closing submissions, to wrap site visits up. And
it may be, sir, that when we've got everybody's availability, there are certain, hopefully there won't be any, but if there are kind of gaps in the programme for hearing oral evidence, maybe you take advantage of that and go on an accompanied site visit.
Yeah. Yes, there may be an opportunity there. We'll have to see how the programme starts taking shape. But initial thoughts were that for the inquiry to open, to deal with preliminary procedural matters, probably even go as far as opening statements, and then perhaps contemplate some site visits then. And it may be perhaps not all, but perhaps some more tailored to when we hear the specific evidence. But certainly, I think, yes, we would look to be doing some early visits. And yes, Mr. Sadler, I think it is. Yes. Thank you.
And a bit more challenging to walk over, just to sort of bear that in mind.
Thanks, Mr. Sadler.
Exactly the same for Coton Orchard.
Thanks, Ms. Gaisley. Yeah, I'd just like to reiterate the point that Mr. Cameron made. A number of suggestions have been put in for site visits along the route by the applicants. If other parties have, I mean, some places may appear self-evident, but if you're involved in the inquiry and there's something that you would like us to go and see, please let the programme officers know as soon as possible so that we can give thought to that and bear it in mind when we're thinking about how to structure the programme for the inquiry overall. Yes, the gentleman at the back. Sorry, I haven't.
Yes, sorry. Can I just ask, do you go by yourselves or do you go with the applicants, barristers and any other interested parties?
Barristers don't normally come. I think on this occasion, most of the site visits would probably be accompanied. If we're accompanied, we'd be accompanied by somebody representing the applicant, and then there'd have to be somebody representing objectors. If we're doing for example, a full day's programme, it would probably be manageable to take all the representatives of all the different objectors, so we'd probably be look to be met by somebody representing different objectors at different locations along the route, but we'd have to kidnap somebody to accompany us if we're going in a group, because we can't be with just one party.
No, I understand that.
So we couldn't go, for example, go around in a minibus just with people representing the applicants.
No.
There'd have to be somebody else with us.
Well, it may be that, say, somebody from CPPF could accompany throughout the whole.
But that can all be arranged.
Yes. I mean, that's just an example. It doesn't have to be them, but...
Yeah.
Thank you.
Okay. Thanks. And just a very brief point about costs applications. We'd just like to know at this stage whether there are currently any intentions on behalf of any of the parties here to make an application for costs.
Shall I start, sir?
Yes.
Not at present. The applicant would only be in a position to do that if there was some evidence of unreasonable behaviour. Yes. So we reserve the right, but have no current intention.
Good. Anybody else? Ms. Gaisley?
Can I also reserve the right? I don't quite know where I am right now.
Yes.
Whilst I have the mic, could I just add one small point? I noticed coming in that it said it's the Greater Cambridge Partnerships Public Inquiry. It might sound like a small point, but even as I was outside talking to, there's quite a lot of national press interest, and I think that will grow as we get closer to the inquiry itself. And I know a lot of people are a bit confused between differentiation of the Cambourne to Cambridge busway scheme and the CSET, which is the Cambridge South East Transport Corridor, which goes to Addenbrooke's and the biomedical campus. I mean, the Transport Works Act order are two separate orders, but they were voted on together at the Cambridgeshire County Council. And I think quite a lot of people think, including the reporter I just spoke to, think that you can embark at Cambourne and get off at the biomedical campus or Addenbrooke's. So I just wonder whether it can be made clear at the sites in the meeting that it's not the Greater Cambridge Partnerships Public Inquiry, but specifically, for example, this one is the C2C one. Thank you.
Yes, it's the other one that you've mentioned is completely separate. We're simply dealing with Cambridge Cambourne to Cambridge, and that's all. And when
What do you mean about the signage and the notices?
but I think the notices that you've seen outside are actually nothing to do with others. I think they've been put up by Wolfson College just to guide people through the site, that's all. And we won't be coming to, and Wolfson College is simply for today. Yeah. Yeah. Okay. Thanks. I think we're more or less there. The other, down to item 11 on the agenda, and all I just want to quickly run through are dates now, so we've got them all in one place, and we'll repeat them in the note for submission of documents. In chronological order, if we could have by the 8th of July hard copies of the documents that we've asked for, if that can be done, Mr. Cameron. And also use that date for anybody who would like to make suggestions for site visits, which we would encourage. By the 22nd of July, we should have, at the latest, I think, the applicant's additional documentation. And there's going to be notification of the ES addendum and a reference to the look at the website to make sure parties are up to date. The next date, the 29th of July, we may fall short of, but that's the date I'm encouraging for statements of common ground, but it may be more realistic to go for the 19th of August. That's the 4-week date by which proofs should be with us, should be with the programme officers for any party intending to appear at the inquiry. If, despite that we've heard nothing today, something occurs between now and then in terms of parties having a view that somebody else has behaved unreasonably ahead of the inquiry, we would like cost applications in advance in writing. Don't want surprises at the last minute when people knew about something beforehand. And I'd suggest 26th of August if you know about something that has happened. But bear in mind that nobody's indicated that yet. Time estimates, 2 weeks ahead, please. By then you'll have seen proofs. You know your own and you'll have seen them from other parties. And then we've already mentioned the 9th of September for rebuttals and any costs responses. 2nd of September, 2 weeks before the inquiry is due to open, Mr. Parker. But we'll set all that out in a note, which will follow as soon as possible. Before we bring matters to a close, is there anything else that anybody needs to raise today? Mr. Cameron.
Only one other point,
Yeah.
sir. On closing submissions,
Yes.
the applicant goes last
Yes.
at the very end, obviously. And a number of different ways of doing this. Sometimes when you have site-specific objections or discrete objections,
yeah,
the objector wishes to close there and then at the end of that session,
Yes.
because they don't want to have to come back again. Sometimes they say they'd like to come back at the end, and if they come back at the end, we then need, doesn't really bother us, but you need some order for them. And it may be sometimes that there's an advantage in having a bit of a break for end of the evidence to then having perhaps virtual closings later. You're going to get something more useful, certainly from us, if there's a bit more time. And we did refer to this, one of the points in the letter.
Yes.
So
I think just
where we are is quite clear at the
Yes.
end, but more time would be advantageous. But it's when the closings for the other parties
Yes.
are going to happen.
Yes, the lady there, please. I can't give you an exact date, but it'll be quite a bit nearer the time. What we will try and do, I think we'll do things in 2 stages. Firstly, in our note of the meeting today, which Mr. Underwood and I will send out, we'll set out the overall structure that we spent some time talking about in terms of who goes first, whether it's one part of the inquiry hearing evidence or not, so that you'll have in terms of of timings, that will be a lot closer to the event. I can't give you an exact date, but it will depend a lot on what you tell the programme officers in terms of how many days, how many hours you need to present your cases. So that's likely to come out quite shortly beforehand, but you will have an idea of where you're likely to, whether you're likely to be in blocks 1, 2 or 3 before then. Is there anything else? Mr. Barker.
So just on closings, from our perspective, I think it partly depends on what decision you make in terms of the giving of the evidence as to when we would want to close. All I would ask is, similarly to Mr. Cameron, that whenever we close, we be given some time after our evidence is finished,
yes,
in order to produce a sensible written closing. Whether that happens in the course of the inquiry or at the end, along with everyone else's closing, I don't have a strong view at this stage. As I say, it may depend. Just picking up on Ms. Treacy's point about when you're likely to publish the timetable, you've already heard our concern about resources and costs, yes, and everything. And whichever way you go, our witnesses and myself, for example, have currently blocked out 8 weeks of our time,
yes,
subject to other commitments. We had hoped, if I'm being totally honest, that we'd get some, while there's going to need to be some flexibility, of course, some indication rather sooner than shortly before the beginning of the inquiry as to when we were likely to attend, because otherwise it becomes unmanageable for us to block out 8 weeks of our diaries, frankly, when we're only, whichever way it goes, yes, we're only going to be attending for 2 weeks.
For a certain number of days.
Exactly.
Yes.
So while I quite understand that the precise timetable depends on timings and may need to be finalised closer to the date, I think whichever decision you make, we would very, very much appreciate an indication as to the, yes, days on which we're likely to,
we'll do our best to produce an indicative timetable.
I'm grateful.
Yeah, but just be aware that once you start sending time estimates in, which inevitably are going to be later on, that may well have a consequence in terms of detail changes.
Understood.
In terms of closing submissions, which Mr. Cameron also asked about, I think our starting point would be that we'd like to hear closings together at the end of the inquiry, with the applicant going last, of course. My usual practice would be to have a break before closings and use that time to do a final programme of site visits. So bring evidence to a close, have a round table session on conditions in relation to the request for deemed planning permission, and then go on site visits and then come back for closings. Yes, Mr. Smith.
It's just a final matter that's not related to closings.
Okay.
I've just been asked to clarify that I am not here on behalf of the University of Cambridge, but on behalf of Clare Hall of the University of Cambridge. I understand that is clear to you and to many people in the room, but I understand it might not have been clear to some people in the room, and I just want to make that clear. Thank you.
Thank you. The gentleman over. Well,
I would have a surefire legal challenge to that, wouldn't it?
I'm not going to take up your invitation, and I'm sure you won't be too surprised at that. Could well be, yes.
Well, I mean, just what after the inquiry, myself and Mr. Clegg will be writing a letter to the Secretaries of State, sort of explaining what a recommendation is. So, in terms of the outcome of the inquiry, what will be is a letter that we will send to the Secretaries of State. Then the Secretaries of State will consider that. So that letter won't be public until the Secretaries of State have considered it, and then after that, the Secretaries of State will actually make the decision on the order and for the open space application, and that will be published. So the Secretaries of State will issue a letter and our letter will be attached to that. So in terms of outcome, obviously we're not going to indicate anything about it, because until we've heard the evidence, we don't know. But in terms of the actual what will happen at the end of the process, that's what it will be. So there will be a time lag between the closing of the inquiry and the time you actually hear from the Secretaries of State on what their decision is.
Is there anything else anybody wishes to raise before the meeting comes to a close? Good. Well, if not, thank you all very much for your attendance today and your participation. As I said, we will issue a note as a record of today's proceedings as soon as we can, and hopefully make progress on an indicative timetable as well. Thank you all very much for your contributions, and the pre-inquiry meeting is now closed.
Thank you, sir. I'll see you in September.
Yes.